Everyone can be seated. Good morning, members of the jury. Thank you. Everyone recalled. Good job. Juror number one, how did I do on the snacks? Very good. You're welcome. Before we get started this morning, I'm going to give you some preliminary instructions as to how the trial will take place, and also an instruction on note-taking. Does everyone have a pen and notepad? If you can hold those up for me so I can see. For the record, each juror has a pen and notepad. After I've given you these two instructions, at that point, the parties will have their opportunities to give their opening statements, and the state will proceed with its case. Once again, throughout this trial process, I will be reading to you quite a bit. Again, it's not that I just do not wish to speak to you in a normal fashion, but the instruction that you are to receive from the court concerning the law during this case is to be specific, and it is to be uniform. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Donna Adelson. This is a criminal case. Donna Adelson is charged with first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. The definition of these offenses will be explained to you later in this trial. The state's charging document, which is called an indictment, is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Donna Adelson in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with final instructions. After the final instructions are given, the alternate jurors will be released, and you will then retire to consider your verdict in this matter. You should not form any definite or fixed opinions on the merits of this case until you have heard all the evidence, the argument of the lawyers, and the instruction on the law that I will provide to you. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, please notify my courtroom personnel concerning the violation. During the course of the trial, the court may take recesses or breaks, and you will be permitted to separate and go about your affairs, or you'll be returned to the jury room. During these recesses or breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, please tell him or her that you are on the jury that is trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to my bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or electronic device is actually off and not in a silent or vibrating mode. You may use your devices during any recesses or breaks, but even then, you may not use your cell phones or electronic devices to find out any information about the case or to communicate with anyone about the case or the people that are involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess or break, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and they will be delivered to you without delay. A contact phone number will be provided to you for this very purpose. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and myself. Jurors must not conduct any investigation of their own. This would include reading newspapers, watching television, using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case, or the people and places that are involved in this case. This instruction is going to apply to you whether you're in the courthouse, at home, or any other location until the trial has concluded. You must not visit places that are mentioned in the trial or use the internet to look at maps or pictures to see any place that is discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest of family members make comments to you or ask questions about this trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages that are related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I will have no way to make sure the information that you have obtained is actually proper and relevant to this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you may find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of the proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and all taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or potentially both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. and it is their duty to make all objections they believe are proper. When an objection is made, you must not speculate on the reason why it has been made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer that question. During the trial, it may be necessary for me to confer with the attorneys out of your hearing to discuss matters that require my consideration alone. It is impossible to predict when such a conference may be required or for how long such a conference may last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of this case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you choose not to. This is going to be an individual choice for each juror. You have been provided with a notepad and pen for your use if you do wish to take notes. Any notes that you take will be for your personal use. However, you are not to remove your notepads from the courtroom. During any recess or break, you are to leave your notepads in your seats. When the trial reconvenes, you will have access to your notepads once again. After you've completed your deliberations in this matter, my bailiff will deliver your notepads to me. From there, your notepads will be destroyed. No one will ever read your notes. If you choose to take notes during this trial, please do not get so involved in note-taking that you've become distracted from the actual proceedings. Your notes should only be used as an aid to your memory. Is the state prepared to give its opening statement at this time?
Yes, Your Honor.
You may proceed.
Mr. Court, counsel. Good morning, everybody. Again, I'm Sarah Catherine Dugan. Georgia Kappelman and I are representing the state of Florida in this case. And this is the defendant, Donna Adelson. We see her here at the defense table, and this is how she appeared back in 2014 when this crime occurred 11 years ago. And the reason that we're here today is because this defendant, Donna Adelson, was part of a conspiracy to hire a hitman to kill her former son-in-law, Dan Markel. This murder was set into motion because back in 2014, this defendant's family had a big problem. And the big problem was Dan Markel. And the solution to that problem was the defendant's son, Charlie Adelson. Charlie Adelson was the solution because he had a girlfriend with connections to the type of people who were willing and capable of pointing a gun at a complete stranger and pulling the trigger. The victim in this case, Dan Markel, was known as Danny to his friends and family. He was a loving father to 2 little boys, and he was a highly respected law professor at Florida State University College of Law. Tragically, on July 18th of 2014, Dan Markel was shot in the head in broad daylight in the driveway of his home in the Benton Hills neighborhood here in Tallahassee. The last day of his life began like any other day of his that summer. He woke up, he took his 2 young sons to preschool, and then he went to the gym to work out. After finishing his workout, he returned home, he pulled into his driveway, and he opened his garage. But little did he know that throughout his entire routine that morning, he was being followed by 2 hired hitmen who traveled all the way to Tallahassee from Miami for the sole purpose of taking his life. And like something out of a horror movie, when he pulled into his driveway, the killers pulled in right behind him. Moments later, Dan Markel's neighbor heard a gunshot, and he looked out the window and saw a light colored Toyota Prius back quickly out of Dan Markel's driveway and speed away. The neighbor thought that was very unusual, very suspicious, so he waited a second to see if Dan Markel also backed out of his driveway or came out of his house. And when he didn't see him, the neighbor got, a very funny feeling. And he went over to Dan Markel's open garage to see if there was anything wrong. And he found a gruesome scene. Dan Markel's car window, his driver's side window, was shattered. His glasses and his phone were on the ground next to his car, and Dan Markel was behind the wheel. He was unresponsive and moaning and terribly injured. The neighbor called 911, and law enforcement arrived to find Dan Markel with a gunshot wound to the head. He was taken to the hospital, where he survived for about 14 hours before he was pronounced dead. Dan Markel was only 41 years old, and his little boys, who were deprived of their father after this murder, were just 3 and 4 years old. Bless you. Law enforcement began to investigate, to try to figure out who did this, who shot Dan Markel. The scene there, the crime scene, left no trace of the killers. There was no fingerprints, no DNA, no bullet casing, nothing was stolen. And so police began to suspect that this may be a professional killing. The little evidence that they do have sends them down 2 separate paths. One path is to track down that light-colored Prius that the neighbor saw fleeing from the scene. And the other is to identify who was inside that Prius. And the other path relates to motive. Who in Dan Markel's life would hate him enough to hire a professional killer to kill him? And after years of tireless investigation, both of these paths led directly to this defendant. So, first let's talk about the path involving motive. We'll go down both paths this morning. Police investigated Dan Markel's personal life to try to figure out a motive in this case, to see who might want him dead. And they learned that Dan Markel was entangled in a very nasty divorce with his ex-wife, who is the defendant's daughter. And his ex-wife is named Wendy Adelson. A review of the divorce case file reveals that Wendy Adelson had asked the court to allow her to relocate to Miami, where she was from and where her parents lived, with her children and Dan Markel's children, in order to be closer to her mother, Donna Adelson, to her father, whose name is Harvey Adelson, and to her brother, whose name is Charlie Adelson. The victim, Dan Markel, as y'all can imagine, is adamantly opposed to this, to his children being relocated to Miami. He works here in Tallahassee. He's a law professor here in Tallahassee. This is where he lives. This is where his kids have been raised. He wants his children here with him. A review by law enforcement of Wendy Adelson's emails made it clear that her mother, the defendant, hated Dan Markel and was the relentless driving force behind Wendy's relocation efforts to South Florida. And being a caring and involved parent is great, but the defendant's participation in her children's lives went beyond mere involvement or even meddling. She was extremely controlling. She had very strong opinions about all the decisions in Wendy Adelson's life, whether it be about her career, her relationships, or even purchasing a home. And if Wendy Adelson would not do as the defendant wanted her to do, the defendant often then enlisted Charlie Adelson, her son, Wendy's brother, to solve the problem by getting him to kind of go to Wendy and persuade Wendy until Wendy ultimately agreed to do what the defendant wanted her to do. And while the defendant had always been controlling of her children's lives, The emails uncovered by law enforcement showed that this defendant was desperate to find a way for Wendy and Dan Markel's children, her grandchildren, to be able to relocate to Miami. The defendant told Wendy that she deserved more than just a life teaching in Tallahassee without her family, and that Dan Markel was essentially holding her hostage in Tallahassee because of his job. During the divorce and custody battle, the defendant's email showed that she was heavily involved in Wendy's court case, even going so far as to draft and edit the documents that Wendy and her attorney were filing in court, and emailing Wendy instructions for her attorney on arguments her attorney should make and what her attorney should do. The defendant would guilt trip Wendy Adelson about how much time she and her husband, Harvey Adelson, were having to spend away from their dental practice to visit Wendy and the grandkids in Tallahassee, and complain about how the family was losing income, losing patients because of their constant absences from the practice. And the defendant instructed Wendy Adelson that relocation to Miami was the most important priority in this divorce, and if it had to be her non-negotiable in the divorce. In June of 2013, the judge in the divorce case ended up ruling in Dan Markel's favor. And not only did the judge deny Wendy's relocation motion, but the judge dismissed it in a way that prevented Wendy Adelson from requesting the relocation again. So Wendy would not be permitted to move to Miami to be close to the defendant and her husband with the children at that time or ever, unless of course something happened to Dan Markel. After the judge denied the relocation motion, after that was denied, the defendant told Wendy Adelson in emails that Dan Markel has not beaten the Adelson family yet. She let Wendy know that the Adelson family is a team and they are trying to win. Donna Adelson suggested in her emails several bribes to get Dan Markel to agree to relocation, like plane tickets, paying for her grandson's education, and the defendant even suggested offering Dan Markel a $1 million bribe to allow the relocation, to let Wendy move to Miami with the boys. And if the bribes didn't work, the defendant also suggested several ways that Wendy could threaten or bully Dan Markel into submission. The defendant told Wendy to aggravate Dan Markel like he aggravates you. And the defendant set out a plan of action that the defendant told Wendy would make Dan Markel absolutely miserable. And she's detailing all of these in her emails. So, for the plan of action, the defendant knew that Dan Markel was devoutly Jewish. So she came up with the idea for Wendy to pose Dan Markel's sons for pictures in front of a Catholic church, and then post the pictures to social media, and even announce on social media she was getting the children baptized just to make it appear to Dan Markel that she was changing their religion. The defendant assured Wendy Adelson that this would all be an act to get Dan Markel to agree to let her move to Miami, but told Wendy Adelson that in order to pull off this stunt, she had to put on the acting performance of her life. The defendant said that it did not matter to her if Wendy had to dress her two little toddlers up in Nazi or SS uniforms, as long as she was able to get them to South Florida and show Dan Markel that he was not in control. the defendant repeatedly told Wendy Adelson that the rest of her life, meaning Wendy's life, as well as the defendant's life, Harvey Adelson's life, and Charlie Adelson's life depended on Wendy Adelson and the boys being able to relocate to Miami. And the defendant said that she would never, never, never give up and never stop fighting for Wendy and the boys to be relocated to Miami. And she never did. The evidence in this case will show you that this defendant's closest confidant was her son, Charlie Adelson. She and Charlie Adelson talk multiple times a day, every day. And he was the person with whom she would constantly vent and complain to about Wendy's situation here in Tallahassee, having to live in Tallahassee with her sons. And she would often, the defendant would use very dramatic life and death terms to describe it. The defendant portrayed Dan Markel to Charlie Adelson as a crazy person who was impossible to deal with and was causing an extreme amount of stress to Donna Adelson and her husband, Harvey Adelson. And Charlie Adelson was also the person that Donna Adelson relied on to solve her problems. And her daughter and grandsons having to live 8 hours away in Tallahassee was a big, big problem for this defendant. And this defendant made it Charlie Adelson's problem to solve. And although the divorce between Wendy and Dan Markel was final a year before the murder, throughout that year, litigation is still ongoing, to say the least. Each side is continuing to routinely file violations of the custody agreement, violations of the settlement agreement, and that continued right up until Dan Markel's death in 2014. A few months before the murder in 2014, Dan Markel alleged that the defendant, Donna Adelson, was disparaging him to his children. He was very worried about her trying to alienate him from his children. She was doing this by calling him stupid in front of the boys and telling the boys that Dan Markel was trying to take them away from her. Dan Markel asked the court to prevent this defendant from having unsupervised contact with her grandchildren. And this motion was still pending in court when Dan Markel was killed. And the murder of Dan Markel ensured that not having access to her grandchildren would never be a problem for this defendant. And what do you know? About 48 hours after Dan Markel was killed, after the shooting happened, Wendy Adelson and the little boys relocated to Miami, moved into the defendant's home with her, and the boys started school down the street. And just like that, their father was effectively erased from their lives, and the Adelsons' big problem had been solved. You'll hear during this trial that the Adelson family is a very tight-knit family. The defendant, her son Charlie Adelson, and her husband Harvey Adelson actually all worked together at their family's dental practice. The defendant, Harvey Adelson and Charlie Adelson are dentists there, and the defendant managed their accounts at the office. She was the details person. And this defendant, though, she managed much more than just the office for the Adelson family. She was the matriarch, and a domineering one at that. She ran the office, the home, and the lives of the Adelson family members. After Dan Markel was killed, law enforcement interviewed Wendy Adelson. Wendy Adelson told police, and the police confirmed this, that she was at home having her TV fixed at her home in Tallahassee, having her TV fixed at the time of Dan Markel's murder. And when police asked her, well, do you know anyone who would have a motive to kill Dan Markel? Wendy Adelson acknowledged that her family had a motive to want Dan Markel dead, and said that her parents had more reason to dislike Dan Markel than anybody else. At one point in the interview, police allowed Wendy Adelson to make a phone call to her parents to let them know that Dan Markel had been shot. And after she got off the phone with her mother, the defendant, Wendy Adelson said to police, well, they acted surprised, so that's a relief. And when asked by law enforcement if anyone could have killed Dan Markel on her behalf, she also told the police about her brother, Charlie Adelson. Wendy admitted to police that her brother, Charlie Adelson, had joked that he looked into hiring a hitman to kill Dan Markel as a divorce present, but decided to buy her a TV instead because it was cheaper. And what do you know? The same TV that Charlie Adelson bought his sister as a divorce gift would be Wendy Adelson's alibi the morning of the murder. An alibi, the TV repair appointment that was set up by her parents, Harvey Adelson and Donna Adelson, the defendant. So this path of looking into Dan Markel's personal life to see who would have motive to kill him leads law enforcement to the Adelsons, including this defendant, a woman who vowed to never, 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 never give up on getting her daughter and grandsons to Miami, and her son, Charlie Adelson, who told his family that he'd looked into hiring a hitman to kill Dan Markel, as Wendy said, was just a joke. But if Charlie Adelson was just joking about hiring a hitman, that joke, that stopped being funny when Dan Markel was actually killed by a hitman. While the police are trying to investigate motive, they are simultaneously following that second path of the investigation by tracking down that light-colored Prius the neighbor saw fleeing from the scene. When law enforcement retraced Dan Markel's steps on the morning of his murder, they uncovered some very chilling surveillance video of that light-colored Prius, fitting the description given by the neighbor, following Dan Markel into the Premier Gym parking lot and waiting for an hour while he was inside, and then following him home from Premier Gym back to Benton Hills. And these surveillance images, coupled with a massive amount of phone and SunPass records gathered in this case, help police track down the exact car used to commit this crime. But police still had to figure out, okay, we got the car, but who was in this car? And why did that person kill Dan Markel? So law enforcement did a painstaking review of digital evidence in this case. And when I say painstaking, finding this Prius and finding evidence in these phone records was not an easy task. And it took much longer than your average investigation of a shooting, as you'll hear. But law enforcement eventually found that needle in the haystack. They found a number that communicated with the cell tower that services Premier Gym at the exact time when the Prius was there. And it was a number with a Miami area code, and that number belonged to a man named Sigfredo Garcia. Law enforcement examined Garcia's call logs, and they saw that he was in frequent contact with another number that was present at Premier Gym that day. And that number belonged to a man named Luis Rivera, who is a longtime friend of Garcia, and he's also from Miami. They both are. Police then looked at Garcia and Rivera's phone records, which showed that their phones left Miami 2 days before the murder, so July 16th. They came to Tallahassee, and on the day of the murder, on the 18th, they followed Markel to Premier Gym. The phone data shows that these men turned their phones off just minutes before the murder took place, and their phones then stayed off for about an hour or so after the murder until they were well southbound to Miami. I think around the Gainesville area, the phones turned back on. And then, once they got back to Miami, a bank's ATM camera caught them in the light-colored Prius at a bank drive-thru and caught both of the men in the Prius. So police figured out the identity of the two men responsible for following and killing Dan Markel. But they continued to look for evidence to explain why these seemingly random men came all the way to Tallahassee to kill a man that they'd never met. What or who is the connection between the killers and the victim? The defendant in her emails obviously had demonstrated ample motive to want Dan Markel dead, but how do we get from these two random and hired killers to her? Well, those phone records that I talked about, they revealed that one of the shooter, Garcia's, most frequent contacts was a woman named Catherine Magbanois. She goes by Katie. The shooter and Magbanois have a long history of an on-again, off-again relationship, and they share two kids in common. This is Garcia and Magbanois. And lo and behold, these two paths of the shooter's car and the motive, they converge when law enforcement sees that Catherine Magbanois is also one of the most frequent contacts in the phone records of Charlie Adelson, the defendant's son. The same son that she had been nagging to death about his sister being stuck in Tallahassee. Law enforcement also learned that at the time of this murder, Catherine Magbanois was dating Charlie Adelson. So, Dan Markel was a problem the defendant needed to solve. The defendant's son, Charlie Adelson, was looking to hire a hitman to kill Dan Markel. Dan Markel is killed by a hitman. And who ended up being the hitman? The hitman that killed Dan Markel? Someone with a close relationship to Charlie Adelson's girlfriend, the father of her children. So you can see how both paths, followed by investigators, charted the way to this defendant. Not only by looking into the motive, led law enforcement to the defendant because of her hatred of Dan Markel and her son's apparent efforts to hire someone to kill him, but also looking into that car fleeing the scene led law enforcement to the defendant through her son's girlfriend at the time. So 2 investigations, 1 conclusion. Law enforcement also tried to follow the money in this case, and that was a 3rd way that the evidence in this case pointed to the defendant. Law enforcement reviewed bank records, employment records, DHS-MV records of all the suspects, and saw that in the months after the homicide, Garcia, Rivera, and Magbanois all acquired some big-ticket items. Rivera and Garcia both bought motorcycles and cars. Magbanois got a breast augmentation surgery and later received a black Lexus sedan whose previous owner was Harvey Adelson. Catherine Magbanois' bank records were analyzed, and there was no check ever written or matching cash withdrawal for the car or the breast augmentation. Bank records also showed that Magbanois' account had a huge spike in cash deposits around the time of the murder. She deposited more money in her account in the 5 weeks after the murder than in the entire year before the murder. And this was during a time when there was no record of her being employed anywhere. And also, about 2 months after the murder, this defendant added Catherine Magbanois to the payroll at the Adelson family's dental practice, the one that she kept the accounts for, the defendant kept the accounts for. And the defendant started issuing her regular checks from their business account every 2 weeks, despite the fact that she did not work there at the time. Magbanowa didn't work there. Law enforcement noticed that each one of the 44 checks that were written to Catherine Magbanowa every 2 weeks over the course of the next 2 years after the murder were signed by this defendant, Donna Adelson. So the money was talking, but what about the suspects? Law enforcement wanted to know what they were saying. In examining the phone records in this case, law enforcement noticed a distinct pattern of communication surrounding important events or dates in this case. The phone calls always went from this defendant to her son, Charlie Adelson, and then from her son, Charlie Adelson, to his girlfriend, Catherine Magbanowa, and then from his girlfriend, Catherine Magbanowa, to the shooter, Garcia, and then back the other way, like train cars. They only seem to touch the car directly in front and directly behind them. The defendant never calls her son's girlfriend, Catherine Magbanowa, or the shooter, or vice versa. Charlie Adelson never calls the shooter, or vice versa. So, if this is a murder for hire conspiracy, as law enforcement suspects, could it be that the defendant and Charlie Adelson are wisely insulating themselves from the actual shooters by having Magbanowa act as the middleman? Law enforcement decided to launch an undercover operation designed to clarify who are the members of this conspiracy and how information was traveling within the conspiracy. Police applied for and received court authorization to listen in real time to the phone calls of Charlie Adelson and Catherine Magbanowa, the people in the middle of this train car. And this is what's known as a wiretap. By this point, though, it was April of 2016. It took about 2 years to do this investigation to find out who was in the car and to get this wiretap going. So at this point, it's been 2 years, almost 2 years, since the murder. And at this point, in April of 2016, Charlie Adelson and Magbanowa are no longer dating. They'd been broken up for over a year. Catherine Magbanowa at this point is actually back together with Garcia. We heard they're on again, off again, and have these kids together. Charlie Adelson has moved on he's had many other girlfriends at that point since Magbanowa. And Charlie Adelson and Magbanowa, though, they are still friends. They remain close friends since their breakup, and they're still in regular communication by April of 2016, even though they're not together anymore. Rivera, the second hitman in that Prius, was in prison by this point, doing time on an unrelated charge. And the defendant is happily taking care of her grandkids all day, every day. So all the members of this conspiracy have presumably gone on with their lives, believing they've gotten away with murder. So what reason would they have to be discussing the murder at that point if police are listening in? They wouldn't. So police needed to stage an event that would generate some conversation, some activity between the members of the conspiracy so they could see who the members of the conspiracy were. Their plan was to send an undercover agent posing as someone on behalf of Luis Rivera. He was the hitman who was incarcerated by April of 2016, to walk up to the defendant, Donna Adelson, on the street. There's a fly right in front of me that won't leave me alone. To walk up to Donna Adelson on the street and try to blackmail her for money. Law enforcement refers to this as a bump. So, this undercover agent posing as a blackmailer, and this is an actual picture from the surveillance cameras, that this is the undercover agent passing a piece of paper to Donna Adelson back in 2016. This undercover agent is posing as a blackmailer. He hands the defendant a piece of paper, and on the piece of paper is a news article about Dan Markel's murder. and written on the piece of paper is a phone number and the amount of $5,000. He tells the defendant that he knows the Adelsons are taking care of Katie, and he's basically there to blackmail to get more money out of them or out of her on Rivera's behalf, to even things out, because he knows they're taking care of Katie. He never says Charlie Adelson's name or anything about Charlie Adelson to Donna Adelson. The defendant then puts the piece of paper in her purse and walks away without ever looking at the piece of paper, because she knew exactly what it was about. Then law enforcement listens in to see what will happen next. Will the defendant go straight to the police to report the blackmail, or will she do something else entirely? And as suspected, based on the previously observed communication pattern, the first person that this defendant calls is Charlie Adelson, despite the fact that the blackmailer never mentioned Charlie Adelson to her. On that first call, you would think the first thing that Donna Adelson would say to Charlie Adelson is, "Oh my God, it's so crazy. Some man just came up to me, handed me an article about Danny's murder, and he's demanding money from us." But she never says any of that. In fact, the defendant never says Dan Markel's name at all. Instead, she tells Charlie Adelson that she needs to talk to him in person about some paperwork that was just delivered to her. She said that it involves the two of us, and that he should know what she's talking about. The defendant and Charlie Adelson continue talking, and she says that he should bring cash to their meeting. And she says, the TV is probably about 5. The defendant tells Charlie Adelson that the man who approached her mentioned an ex-girlfriend. The defendant never says which ex-girlfriend of Charlie Adelson. She never says Magbanwa's name to Charlie Adelson in that phone call. She only says that the blackmailer mentioned an ex-girlfriend. Charlie Adelson never asked his mom, "My ex-girlfriend? Which ex-girlfriend?" He's had a lot. He never asked that, because as the evidence will show, he didn't need to. He knew the TV is probably 5 meant that she was being blackmailed about Danny's murder, where the TV was the alibi, and he knew that the ex-girlfriend in question was the only ex-girlfriend that he had solicited to find a hitman for him, Catherine Magbanwa. And we know that because after this call with his mother, the defendant, Charlie Adelson, calls Catherine Magbanwa. He does not call his most recent ex-girlfriend or even the one before that. He calls Catherine Magbanwa. And his call to Catherine Magbanwa is the only call he makes to any ex-girlfriend after getting the information from his mother that the blackmailer mentioned an ex-girlfriend. And he hadn't dated her for about 1.5 years at that point. And although they threatened to do it very often, neither Charlie Adelson nor the defendant ever reported this attempted blackmail to the police. You all will hear the calls between the conspirators, and as you listen to these, you'll notice that they're being very cautious about what they say. It's apparent that they're being very careful about the words they use, because they are all immediately suspicious that law enforcement could be behind the bump. Law enforcement could be the person who came up to them on the street and gave her the paperwork, and law enforcement could also be listening to their conversations. After Charlie Adelson's first call to Catherine Magbanwa, Charlie Adelson then meets up in person with his mother. the defendant. And in person, she gives him the paperwork that this blackmailer gave to her and makes it Charlie Adelson's newest problem to solve. And naturally, what does Charlie Adelson do? He goes to the next train car, Catherine Magbanua. Charlie Adelson and Catherine Magbanua meet in person at a restaurant called Dolce Vita in Miami. And while they sit at their table in this busy, noisy restaurant, an undercover FBI agent is sitting at a table nearby with a camera hidden in a bag, recording the conversation. So this is an image from that video recording the conversation. And in the recording, we hear Charlie Adelson discussing whether the man who walked up to his mother could be an undercover police officer, or he could be someone trying to legitimately blackmail them. And if it's a blackmailer, is it somebody who just saw a way to make a quick buck? Or is it another situation entirely, which would be much worse for the Adelsons? Is it actually someone with inside information about Donna Adelson's role in the murder of Dan Markel? And that person could tell police what they know. Charlie Adelson reassures Katie, Catherine Magbanua, that if it is the police, that is a good thing. Charlie Adelson thinks that, hey, if it's the police, that means the police don't have enough evidence to charge anybody. You know, they're just fishing for information. And in fact, Charlie Adelson tells her, hey, if they had any evidence, we would have already gone to the airport. It's important to note that at the time of this conversation at Dolce Vita, no arrests had been made in this case. And the only thing that police had released to the public at that point was a photo of the light-colored Prius that fled the scene. Police knew at that point that it was Garcia and Rivera who were in the Prius, but the public didn't know that yet. So that fact is interesting in light of some of the things that Charlie Adelson started saying to Magbanua. He starts giving her several analogies involving rental cars being used to commit crimes. He reassures her that the police can't prove a person committed a crime just from someone's DNA being in a car that was used in a crime. In order to prove someone committed a crime, you have to be able to put the person at the scene of the crime at the time it was committed. So he's trying to reassure her that even if they identify who rented that car that fled the scene, they still would not have enough evidence to hold anybody responsible for this murder. Charlie Adelson also says that crimes are tough to prove unless someone actually witnessed the suspect commit the crime, or the suspect confesses to the crime, or a suspect is caught on a wire talking about the crime. So he's trying to reassure her about the lack of evidence in this case, about no witnesses, and trying to let her know that, hey, as long as we all stay quiet and nobody confesses or gets caught talking on a wire, then we don't have anything to worry about. And he begins educating Catherine Magbanua about how blackmail works. He tells her that, hey, if this is a guy who knows information, there's two ways of dealing with this guy. You know, we could call the police, but then the guy blackmailing us could be charged, and then that blackmailer is going to start talking, and the police are going to be asking questions about what happened. The other option is to pay the blackmailer, but let him know that this is just a one-time thing. And we'll try to scare him off by saying, if you come around again, we'll go to the police. Charlie Adelson gives Magbanua very precise instructions on how to deal with the blackmailer. He tells her to call the blackmailer and tell her that my friends, meaning the Adelson family, have no idea what you're talking about. And I'm just going to give you this money as charity. But don't contact these people again or they'll go to the police. And Charlie Adelson said he would give Magbanua the $5,000 to pay off the blackmailer who approached his mother, except that he's concerned that this guy won't go away. he'll get that $5,000 and then he'll just keep coming back for more money. We'll see him as an easy target. And so Charlie Adelson then offers that the best solution might be to have the blackmailer killed, and that he's willing to pay whatever it takes. He says, "So help me God, if they F with my family, it's going to be Nazi shit, because this will be done. I mean, Katie, I don't care what I spend." And after hearing that Charlie Adelson wants someone killed and is willing to pay whatever it takes to get it done, Magbanua then asks Charlie Adelson to help her out. And Charlie Adelson reassures her she'll be taken care of and reminds her she's on salary at the parents' dental practice. After Charlie Adelson finishes this meeting where he's getting Magbanua to then solve the problem of the blackmailer, he gives her they say goodbye, he gives her a big hug that's captured on camera outside by the FBI, and then Charlie Adelson immediately calls the defendant to let her know everything's fine and he has handled the situation. He does this using some pretty obvious code words that you'll often hear these conspirators use to mask the meaning of what they're talking about in case law enforcement's listening. Magbanua then, also using code words, calls Garcia, and she tasks him with calling the number on their paperwork and finding the identity of the blackmailer. And in the series of recorded calls that y'all are going to hear later this week, you'll hear these conspirators talking and using words like TV, relationship advice, false leads, listings, patients, properties, clients, rap songs, CDs, pigs, all these terms that are obviously normal words, but they're used in context that, if you're listening to the conversation, don't make sense. So after that undercover operation was over in 2016, Luis Rivera and Sigfredo Garcia are arrested, and they're charged with the same charges before y'all in this trial. Luis Rivera, who was the second person in that Prius, cut a deal with the state and told law enforcement the truth about the murder of Dan Markel and the people responsible for it. He told police that he was hired by his longtime friend Garcia to help kill Dan Markel. Rivera described how Garcia told him that this was a job that Magbanua was able to get for them, and it was in Tallahassee, and it paid $100,000, and that Rivera was going to get a third of the money. Rivera said that during the trip to Tallahassee, Garcia had a piece of paper with a picture of the man that they were hired to kill and some handwritten notes. And during that trip, Rivera said that the first call that either of them made after the homicide was from Garcia to Magbanua, where Garcia told her that the job was done and Magbanua assured them they would get their money the next day, which they did. That Magbanua brought the money the next morning to Rivera's home. And law enforcement checked cell phone records, which corroborated Rivera's information. Law enforcement told police that the money that he received from Magbanua the next day was packaged in a very unusual way. The money was basically in stacks of 1,000. Each stack was made up of $100 bills that were then stapled together. And after each stack was stapled together of 1,000. And after learning this from Rivera, Magbanua was arrested, and that was in October of 2016. During this trial, you'll hear that the Adelson family had access to a lot of cash because their family gave cash discounts at their dental practice. Like if you paid in cash, you would have to pay less than if you paid on a card or check. And they kept the cash that they received in stacks, and they stored it in a safe. Law enforcement also learned from Charlie Adelson's friends that Charlie Adelson had a very unusual practice of keeping his money in these $1,000 stacks that were stapled together, just like the money Rivera received. And over the last few years, since the 2016 arrests of Garcia and Rivera in May, and then of Magbanua in October 2016, law enforcement has not stopped working on this case. 3 years after Garcia's arrest in 2019, he was convicted at his trial. Law enforcement continue, though, to gather evidence. They continue to interview people who may possibly have information and to clarify all of these recordings the FBI did that couldn't be clearly heard. And thanks to their tireless efforts, in March of 2022, Charlie Adelson was indicted. 2 months later, in May of 2022, Catherine Magbanua's case went to trial, and she was convicted. During Magbanua's trial, Catherine Magbanua took the stand, and she insisted, this is back in May of 22, she insisted she had no knowledge of the murder. The Adelsons must have just gone around her to hire the hitman directly. That's what she testified to. Her defense team insisted that the state's theory was correct about every co-conspirator except for her, for Catherine Magbanua. That Catherine Magbanua was just this victim of bloodthirsty and desperate prosecutors and investigators, and just a victim of this set of circumstances that appeared to prove one thing, but was actually, the truth was something else entirely. However, after being convicted at trial and sentenced, Magbanua finally decided to testify about the plot to kill Dan Markel, and admitted that she was the connection between the Adelson family and the killers hired to kill Dan Markel. Magbanua testified in Charlie Adelson's trial in October of 2023 and said that Charlie Adelson wanted to hire someone to kill his sister's ex because his mom was stressed out over all of the problems his sister was having with her ex-husband. Magbanua said Charlie painted a picture that Wendy's ex was this terrible man causing his mom so much stress that she couldn't sleep or eat. Magbanua agreed to help him and ended up recruiting her children's father, Garcia, and also Rivera to kill Dan Markel. She says that the night of the murder, she went to Charlie Adelson's house to pick up the payment for the murder. And when she arrived, Charlie Adelson said that his parents had just been at the house and that Charlie Adelson had the money for her there. Law enforcement was able to corroborate this claim with phone evidence showing that Donna Adelson went to Charlie Adelson's house the night of the murder. Magbanua then spent the night with Charlie Adelson that night, and the next morning, on July 19th, he put the money that she was to divide up into the trunk of her car. Magbanua says several things about the money stood out to her. She said it was stapled together in stacks of $100 bills, and that it was damp like wet. She then delivered the money to Garcia and Rivera afterwards. When Catherine Magbanua said that when she asked Charlie Adelson about the money being damp, he said that his mother the defendant, had actually washed the money, and that she and Charlie Adelson kind of laughed about the fact that the defendant had literally washed the money so it couldn't be traced. In Charlie Adelson's trial, Charlie Adelson took the stand, and he testified that Magbanua, Garcia, and Rivera were all in on this crime together, but that the Adelsons had nothing to do with it. They were the innocent ones. He crafted an elaborate story in which Garcia and Rivera came to Tallahassee on their own, killed Dan Markel without his knowledge or his family's knowledge, and then these killers colluded with Magbanua to play he and his mother for fools and extort money out of them. And for many reasons, which will be revealed to y'all in this trial, Charlie's interpretation of the facts was not reasonable to believe, and he was convicted. Charlie Adelson was convicted in November of 2023, and within hours of his guilty verdict, this defendant began to plan to flee the United States to a country that she could not be extradited from in order to avoid being arrested for Dan Markel's murder. The defendant on her phone researched countries that did not have extradition treaties with the United States, and she applied for an emergency visa to Vietnam. She was overheard planning to put her money in trust for her grandchildren, and she and her husband purchased one-way tickets with a fast-track emergency visa to Vietnam. And Vietnam does not have an extradition treaty with the U.S., as she would have learned from her searches. And just days later, she was stopped by law enforcement on the jetway in Miami International Airport, where she was boarding her one-way flight to Vietnam, and she was then charged for her participation in the murder of Dan Markel. After the defendant was charged, law enforcement received information from women who said that the defendant, Donna Adelson, was offering them bribes in exchange for false testimony in this trial. They said Donna Adelson promised them money, housing, veneers, prescription drugs, if they were willing to testify that Catherine Magbanua told them a completely different story about the crime than the one that she would be testifying to. One informant was even able to show law enforcement a script, a question and answer session for a direct examination in trial that Donna Adelson herself wrote, and that Donna Adelson wanted this informant to memorize and come into court and perjure herself by reciting it to you here in trial. Please listen to all of the evidence that y'all are going to see and hear in this trial. I know it's been a long week already, and we have a lot of evidence for you in this case, but when you do, you will see that this defendant conspired with her son, Charlie Adelson, who solicited his girlfriend, Catherine Magbanua, to get this murder done. And then this defendant paid her with cash, with checks for the job once it was completed. The defendant acted in furtherance of this murder plot that went beyond just thinking about it or just talking about it. And these acts make her guilty as a principal to first-degree murder, just as if she was the one pulling the trigger in the garage herself. And while the defendant's choices helped solve a problem within her family, they came at a very high price. She took the life of a loving father of 2 little boys and caused a lifetime of grief for Dan Markel's loved ones. And at the conclusion of the evidence in this case, you will be convinced beyond any reasonable doubt that this defendant is guilty. And at that point, we'll ask you for the only verdict that does justice in this case, which is a verdict that this defendant is guilty as charged. Thank you.
All right, briefly approach. Before the defense gives its opening statement, we are going to take a brief break. The bailiff will take you to the jury room. Gallery or the observers need to use the restroom, please do so at this point, so that way when the defense is ready, we can continue moving on seamlessly. We'll resume again at 10:20. defense set up at this point?
Yes, sir.
All right. Is there any further clarification needed about what was discussed at the sidebar?
Not at all, Your Honor.
All right, very good. You can be seated, but they're coming right back in, so it's probably going to be some pop goes the weasel, musical chairs, whatever your variation is of that. 14 people wrangling the bathroom will be a thing throughout the trial.
educate himself so that he could get tenure at the law school as a professor. He worked very hard. He earned a lot. What he did not earn was for somebody to do this to him. You're going to hear that Wendy Adelson, the daughter of my client, was married to Danny. And I'm not trying to be informal when I say that. I respect Mr. Markel, Dr. Markel, but because so many people in the trial are going to refer to him as Danny, I'm going to do that if that's okay. But I don't mean any disrespect by doing that. More important to Danny Markel than anything in the world were his little boys. He had 2 little children when this happened to him, a 3-year-old and a 4-year-old. When the divorce first happened, when Wendy moved out, he did not want the divorce. That was in 2012. And they squabbled during the divorce, they did. Each side argued for their side. The other side argued for their side. That's what happens in divorce. Divorce is not fun. Divorce is not usually friendly. Some of us have had friendly divorces, but not everybody does. And a lot of things were said. But moving forward to 2014 is where we're going to concentrate on, because that's when Danny was killed. And in 2014, with these little boys that he had, the divorce had been over for a year. Relocation, the opportunity, even discussion about it, ended. On July 31st, when the final judgment was entered, relocation was over. The state told you that. The court denied it with prejudice. She could never raise it again. Nobody was fighting anymore about where these little boys would be. Danny advocated for not only himself in the divorce, he advocated for his children. They are an important part of his life. He wanted as much time as he could get with them. They ended up splitting the time equally between Wendy and Danny. Their schedules changed a little bit on how they worked that out, but it was 50%. This bug is driving me crazy too. What in the world is that? Sorry. He continuously, from the time Wendy moved out till the time that he was killed, spent as much time as he could get with his children. He loved being with them. If it wasn't his time to have the children, he would go to their little preschool and spend time with them there. He wanted to talk to them on the phone as much as he could. You guys are way younger than me, so maybe you don't even know about this, but I guess there was a thing called Skype. I don't even know if it still exists, but I guess it's like FaceTiming, but doing it on your computer. And that's how he wanted to talk to his kids, so that he could see them when he wasn't with them while he spoke to them. Now, at 3 and 4, it's kind of hard to wrangle them to sit down in front of a screen. So Danny came up with a really good idea. When he Skyped the children, it would be most of the time after the kids had had their dinner and had their baths, where they're kind of calmed down, they're not in their little running around state. And he would read bedtime stories to them. When he didn't have his little kids, he still wanted to know that when the children went to bed, they didn't forget about Daddy. And he made sure that didn't happen. These kids are not deprived of their father. Their father was brutally taken from them. Not just when they were 3 or 4, or 5 or 6, or 7 or 8, but up into their teens. They lost the opportunity because someone took it from them to grow up with a father, to have his involvement and influence in their lives, to talk about what he did as a kid and share his experiences. All of that was stolen from him. That's very important. This Skyping that he did with his kids, Mrs. Adelson, when she had the little boys, actually arranged so she could do that with him. And she would keep the kids in front of the screen while he talked to his children. You've heard a lot about how she hated him. She said some ugly things during the divorce. Pretty foul things, actually. But you're going to learn through the evidence why that was occurring and how she was actually interacting with Danny. They're two very different things. I want to talk to you now about my client, Donna Adelson. She is a normal person, just like all of us. At the time that this happened, she was 64 years old, married to her husband, Dr. Adelson, a dentist. Now they've been married 54 years. It was somewhere in the 40-year range when this happened 11 years ago. And she got up in the morning and went to work, not at her and Harvey's business, like you were just told. She went to the business owned by her son. Every morning, they got up and they went to work. She did the books, she kept the books, she greeted patients, she got charts out. At 7:30 every morning, she was there and organized and had everybody ready to go because they had a little staff meeting. So everybody could know what to expect, what patients they were going to see, what they were going to take care of. She was there working, sometimes late into the evening, just like all of us. She's a normal person. People who know Donna will tell you that she is not the person that the state is portraying her to be. She's kind, caring, loving. She cares more about people than she does about herself. Now, what happened on July the 18th of 2014? You've heard the state describe it, but I want to talk about it for a minute. The state is going to be able to prove to you some of the things they were talking about. Can everybody see it okay? No? Oh.
This is arranging the easel. Just raise your hands and everyone can see the easel clearly. Thank you.
Thank you. Thank you. So the state told you that he got up every day, just like he normally did, on July the 18th of 2014. And I just want to say this also. Throughout the trial, you may hear me say that he was murdered on that date. Somehow he survived for another 11 hours. But in my opinion, all the evidence is going to show that what killed him took place on the 18th, and he was just able to survive long enough into the next day. So on that date, July 18th of 2014, these two men, Sigfredo Garcia and Luis Rivera, followed Danny all over town. Started at his house, followed him to the school where the little children were going to school, the preschool where he dropped them off, watched him drop those kids off, followed him to the gym, waited outside the gym for him, followed him to his house, pulled up in the driveway. Mr. Markel is talking on the telephone to someone, and he notices someone's coming into his driveway. And while he's talking on the phone and says something about needing to see who this is, he turns and looks in the direction, and this man, Sigfredo Garcia, is holding a revolver, and he points it at him. And you may hear testimony that there's some evidence that maybe he tried to, well, you know what you do in defense when somebody's going to hit you or whatever, you put your hands up. He saw this man pointing a gun similar to this at him. And in that instant, I cannot fathom how terrified he must have been when this man shot him, not one time, but twice. One of the shots is almost right between the eyes. He was brutally murdered by this man. This man, Luis Rivera, who you've heard them mention in the state's opening, traveled with this car. This is an actual picture of the car, and the state's going to show it to you. This is the Prius that they were traveling in. This is a surveillance photo that the investigators were able to find to know that it was a Prius that they were looking for. This man supplied the gun and drove the car following Danny, drove it up into the driveway less than 3 feet away from Mr. Markel, whose engine is still running, and he's on the phone, and he waits while this man kills him. He hears the shots. This guy, Mr. Garcia, runs back to the car where Mr. Rivera is in the driver's seat, and he's the getaway driver. Supplies the gun, knows what they're going there to do, kill him, and drive off. They drive off. The state can prove that about Sigfredo Garcia and Luis Rivera. But they're not on trial here, right? You heard they've already been on trial. Then you're going to hear, as the state said, that they can prove that, everybody can see okay? They can prove that Katie Magbanawa, her name's Catherine, some people call her Katie, they can prove that she's the one who set it up. This is the father of Katie's children. This is his buddy that was recruited to go along on this trip to kill Danny. They can prove that she arranged these guys to do it, and that she's the one who paid them the money. The money that was in stacks, stapled, $100 bills, all $100, well, there may have been something other than $100 bills, but each stack was $1,000, stapled together. And you're going to hear testimony that that's exactly what he did with his money. He kept it and saved it for a long time. And you're probably going to hear testimony that this happens on July 18th, and on July the 19th, Mr. Adelson, Charlie Adelson, which is her son, gave approximately between $130,000 and $138,000 that he had in his safe, that he collected and stapled together. His money went to her, not Miss Adelson. They can prove and have that he paid her to get them to kill Danny Markel. That's what they can prove. And they've done it 1, 2, 3, 4 times. This case is really a lot about theory and motive and not evidence. The state has a theory, and for the past 9 to 11 years, in fairness, probably 9 years, they have told the whole world that Mrs. Adelson was the reason that this happened. Mrs. Adelson was the reason that this happened. They've told this story, and it's outrageous. It gets people's attention. It's made a lot of money for the media, interviews, specials. Some people in jury selection said they had watched these specials. Lawyers on there, investigators on there. They made a lot of money for the media, and it got big attention because this is outrageous, what happened. It is truly outrageous. But what's more outrageous is, without any evidence, only motive and theory, they put her at the top of this pyramid. She's the matriarch. She's the matriarch mastermind behind Danny being killed, and they don't have evidence of that. That's what's outrageous. It's outrageous that he got killed, but it's also outrageous that we're sitting here with a jury, and you're going to hear a lot of theory, a lot of motive and a lot of what they believe the evidence means. They don't get to decide that. The evidence is what the evidence is, and I ask you to patiently sit here and really pay attention to all of the evidence that you hear, every witness that they put on, every piece of evidence that they present to you. All of it. Don't, for 1 second, I'm not asking you to ignore any of that. Please listen to all of it closely. Look for what they actually have as evidence that Mrs. Adelson planned. She planned Danny Markel's murder. That she engaged these men to kill him. And that she gave the money to her son to give to Katie to pay them. You won't find evidence of that. The evidence about the $3,000 a month, I have that here on this board. $3,000 a month. Charlie Adelson gave $2,000 a month, and he instructed his mother, for reasons you're going to learn in the trial, out of his business account to put her on payroll. She worked for him and she paid that money. It's this man's money, not Donna Adelson's. At the end of listening to all of the evidence, we're going to have an opportunity to make closing arguments. And the judge is then going to give you, well, he's going to give it before, he's going to give you all of the instructions on what it is that you have to decide. Did the state charge and then prove that Mrs. Adelson committed a conspiracy? Not one of the elements, all of the elements, proven by evidence, not theory, not motive. For each count, then solicitation, all the elements. So while you're listening to the evidence, you don't know what those elements are, but think about what each thing it is that the state has alleged. She planned it. She got people to do it. She intended that he die. That this woman wanted to take away the father of her grandchildren for the rest of their life because of relocation that happened a year ago and was done and over. And at the end of the case, because there's not going to be evidence that she did this, keep an open mind. Listen to all of it. We're going to ask you to find her not guilty of every single count. Thank you.
Thank you, Ms. Fulford. Zelman, if you could take down the easels at this time. Is the state prepared to call its first witness?
Yes, Your Honor. The state calls James Geiger. May I reposition the lectern, Judge?
Geiger, please raise your right hand to be sworn, sir. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You may take your seat. Please speak loudly and clearly for the jurors. You may examine your right.
Yes, sir. Perfect. Thank you. Please say your name and spell your name.
My name is James Geiger, Geiger.
Sir, where do you live?
I live at 2122 Trest in Tallahassee.
How long have you lived at that residence?
It's getting pretty close to 50 years now, I think 48 or 49.
All right. I want to take you back to July 18th of 2024. Now I've got an ad on me. Do you recall something unusual that happened that day? I'm sorry, I said 2024. 2014, sir. You know what case we're here about. Do you remember what happened on that date?
Yes, I do.
All right. Could you please tell our jurors how something unusual first got your attention?
It was a Friday morning, about 10:30. My wife and I were sitting in our living room looking out towards Trescott Drive, out to the street. And as we were sitting there, we were doing something with our iPads, and we heard a noise, a popping, loud sound, bang sound. And we immediately got up and walked to the front. We have a big picture window. Walked up to see if we could determine what had happened and where it had come from. We weren't sure it was to the right or to the left. And,
all right, let me pause you right there and show you a couple photographs that I have as marked as states 1, 2, and 3.
Okay.
Do you recognize these photographs, sir?
Yes, I do.
Are these fair and accurate photographs of your residence at that time, as well as the view from the window you've described?
Yes, it's true.
Judge, at this time I'd ask to admit 1 through 3 and publish.
Any objection?
No objection, Your Honor.
States 1 to 3 are admitted.
If we could publish states 1, please. All right, sir, so if you could just explain, give me that pointer, please, what we're looking at in this photo, and I've got a pointer here, if that's of any assistance to you. Push the middle button, you get a red dot. You don't have to use it. Oh, if you are going to use it, though, use it on the big screen, please, sir. All right, so just describe what we're looking at in this photo, states 1.
This is taken from Trescott Drive. The house on the right is my house, and the house on the left was Danny's house.
Okay, and the bay window that you've described, is that what is pictured in this portion of the photo right here? Yes, sir.
Yeah, that's correct.
Publish states 2, please. Sir, is this the view from that window?
Yes,
All
this
right.
is what I saw as I looked out.
Okay, and the driveway that we can see there on the right side of the window, is that Dan Markel's driveway?
Yes, it is.
All right, so you've described that something got your attention. Can we have states 3, please?
Well, as I mentioned, I wasn't sure where the noise had come from, and I looked to the left and to the right, and as I looked to the right, there was a car that was rapidly backing out of the driveway and immediately headed down in that direction towards Benton Road. It caught my attention because it seemed to be going so fast. And I noticed what it looked like, and that caught my attention, although quite frankly it was out of the corner of my eye. It appeared to be a Prius, a light-colored Prius, maybe silver or white.
Okay, so something got your attention. What was that?
Well, that was what got my attention, and then
Was the vehicle itself?
Excuse me?
Was the vehicle itself, or some noise preceded you seeing the vehicle?
Well, initially we had heard this loud noise, which we weren't exactly sure it was. It could have been a gunshot, we weren't sure. And then when I saw the car back out, that prompted me then to walk next door there had been in the neighborhood a few break-ins, burglaries, and my first thought was that somebody was trying to break into the Markel house. And so I went out the front door and walked across over to Danny's house to see if anything had been damaged, maybe tried to be broken into the garage or something.
Yes, sir. When you looked out, you said you saw the car back out and then exit toward Benton Road. Would that be going this direction to the right of the photograph or toward the left of the photograph?
It would be towards the right.
Okay, so out this way. And you said you walked over there just to sort of look around, make sure everything was okay. What did you see?
As I approached his garage, I noticed that the garage door was open, his car was inside, and the motor was running. And so I thought then, well, I guess so much for a burglary. I don't think that's happened if Danny's there. So I turned around and walked back to my house.
Okay. What happened next?
After that, I can't tell you why, but I just stood at my front window and looked out and waited for a few minutes, maybe 3 or 4, up to 5. And for some reason, it just didn't quite seem right. Danny hadn't backed out, and I thought by this time he should have backed out of his driveway, and he didn't. And so I said to my wife, I think something just seems wrong. I'm going to walk back over. And so I did that.
All right. And what did you see when you got over there?
Excuse me?
What did you see when you got over there the second time?
Well, when I went back the second time, I noticed that the garage door was still up, the car was still running. And this time I thought, maybe I better walk on into the garage. He's probably in the driver's seat. He's probably on the cell phone talking, but I just wanted to make sure everything was okay.
Yes,
And
sir.
so I walked into the actual driveway then, and I saw that the window, the driver's side window, had been shattered, and I stepped on glass at that same time. As I looked inside, I saw a bloody head, and the head was slowly moving back and forth, rolling back and forth, left to right. And I hollered immediately, "Danny, what happened?" And I didn't get any response other than the head rolling, and so I hollered again, Danny, what's happened?" Still nothing. And at that point, I knew that I had to get the emergency medical team there as quickly as I could. I reached into my pocket to pull out my cell phone, which is where I normally keep it, and it wasn't there. And I thought, gee, I've left it back on the couch at the house. And so I quickly dashed back to the house, got the phone, and called 911.
How many minutes do you estimate elapsed between the time you saw the Prius backing out, or really I should say the time you heard the loud bang, to the time that you were able to reach 911?
Less than 10 minutes, more than 5 minutes, somewhere in there, I would say.
I'm going to approach and show you what I've marked as State's Exhibits 4, and then I also have 6 and 7. This is number 4, and I'll draw your attention to some initials on number 4, and then also 6 and 7.
Mm-hmm.
Do you recognize these photos?
Yes, I do.
All right, Judge, at this time I'd ask to move into evidence 6 and 7.
Any objection?
No objection.
States 6 and 7 are admitted.
Publish State 6, please.
You may.
Sir, is this how the vehicle was positioned when you went over there and found Mr. Markel so badly injured?
Yes, that looks correct.
Publish State 7, please. Was the doors to the vehicle are open in this photograph? Were they open or closed when you went over?
No, they were all closed.
Okay, closed, and the only window that was damaged was that the driver's side window?
That's the only one I saw. That's, if there were some others, I didn't look at any other windows. I just simply saw the driver's side that was completely shattered.
All right, yes, sir. And State's Exhibit 4, is this consistent with the type of vehicle that you observed in the driveway backing out that day?
Yes, it was, although I didn't quite see that angle.
Okay. Judge, at this time, I'd ask to introduce State's 4.
Objection to States 4.
No objection.
Admitted at this time.
All right, and you described it as a light-colored Prius. You weren't exactly sure of the color, maybe white, maybe silver, right?
Yeah, silver came to mind first, I guess, but certainly a light-colored vehicle.
I'm going to approach and show you State's Exhibit 5. Recognize State's 5?
Yes,
Is that Mr. Markel?
yes it is.
All right, may I introduce State's 5, Judge?
No objection. States 5 is admitted.
Publishing State's 5. What did you know about Mr. Markel?
Well, this occurred in 2014, and Danny and Wendy were newlyweds and had moved in about 5 years earlier than that. They moved next door. We were not particularly close to either one. We would see them occasionally out on the street. The memorable thing, and the other neighbors would tell you, is that when they first moved in, they had a housewarming event, and they invited all the neighbors in, and we attended it. That was our first time to see them and visit them. They seemed like a nice young couple, and but after that, we weren't particularly close.
Did they have a couple little children living there?
Well, when they first moved there, they didn't, but after a year or two, they had a first child, and then later a second child.
All right, and at the time that Mr. Markel was shot, had his wife, Wendy, moved out? Had they separated?
Yeah, we had understood that they were going through a divorce, and Wendy had left, and after that, we rarely saw Danny, and I don't think we ever saw the kids either, but
Were you familiar with Mr. Markel's profession?
yes, I knew that he was an attorney. Both of them were, and they were connected with the FSU Law School, I believe, but I didn't know their exact positions there.
Yes, sir. Publish 4 again, please. Are you able to tell the jurors anything about the occupants of this vehicle on that day?
No, I only saw it just briefly, and to notice what kind of car it was. I couldn't tell you who was inside. The windows were dark as far as I could see. I didn't even know if it was 2-door or 4-door. I just didn't see anything like that.
During the time that you were present at the scene of the shooting, did Mr. Markel ever regain consciousness or ever say anything that you heard?
No, I never heard him say anything. The only notion was that his head kept rolling back and forth during the 911 call, which it took forever to try to get the emergency vehicle there, the emergency medical team. They would occasionally ask if he was still breathing. And I would walk back up into the garage, and his head was moving still. And I said, well, his head's moving. So I assume he's still breathing.
Yes, sir. Have you had an opportunity to review that recorded call that you made to 911 that day?
Yes, I have.
All right. And was it a fair and accurate recording of that call?
Yes.
All right, Judge, at this time I'd ask to move into evidence States 88.
Any objection?
No objection.
States 88 is admitted.
May I publish?
Go ahead.
What's your emergency? It's right next door at my house, which is 2122 Trescott Drive.
Can you repeat that for verification?
2122 Trescott Drive, T.
Okay, and the phone number you're calling from?
I'm calling from 850-2.
Okay, tell me exactly what happened.
We heard a loud bang and crossbow away from next door. I came over and looked in, the garage door was up, Now, I thought the gentleman was backing out, and I went back to my house, but he never backed out, and I came back over, and his driver's side window is shattered, and he's battered, and can't answer. He's inside. I don't know if somebody tried to shoot him, or if he shot himself, or what, I don't know.
And it was at this location, correct?
Right next door. I'll give you mine. I don't know his address. It's next door.
Okay.
He didn't send an ambulance in a hurry. EMG. He's still alive. He's moving.
Okay. What's going on with it?
I don't know. The driver's side window is all bashed in. He's inside. The car is running, and he's got blood all over his head. He's not responding to me. That number, by the way, is 2116. 2116.
All right, that's the first few minutes of a 14-minute call. Is that how long it took them to get somebody to you?
Seemed to me a lot longer,
Seemed like 14 hours, didn't it?
long time.
Nothing further, Your Honor.
Cross-examination for Mr. Geiger.
No question, Your Honor.
Mr. Geiger, you may step down, sir. Is he released from his subpoena? Will anyone need to recall him for any purpose?
He's released, Your Honor.
Have a good day, sir. Please call your next witness.
The state calls David Sims.
Judge, before he's just asking me to approach, please.
Please approach. Please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give will be the truth? I do. You may take your seat. Please speak loudly and clearly for the jurors.
Sir, please introduce yourself and spell your name.
David Sims, S-I-M-S.
How are you? Go ahead.
Retired sergeant from Tallahassee Police Department.
How long were you with Tallahassee Police Department?
28 years.
Okay. And were you employed with them back in 2014?
Yes.
Did you respond to a scene in response to a 911 call 2116 Trescott Drive on July 18th of 2014?
Yes, I did.
Is that location in Leon County?
Yes, it is.
All right. And do you know what time you were dispatched to the call?
I was not dispatched. I was actually at the station working on paperwork, and I heard the call go out, so I just responded.
Okay. And were you the first or?
First on scene.
You were first on scene.
Yes.
And did you make contact with Mr. Geiger, the neighbor?
Yes, I did.
And did Mr. Geiger indicate something going on in the garage next door to his residence?
Yeah, he said his neighbor, he thinks it was his neighbor in there, and he heard a loud noise, and there was broken glass in his car.
All right, I'm gonna publish states 7, please. That's in, right? Yeah. Has the vehicle been moved from the position it was in when you first arrived?
No.
Okay, other than the doors being opened, right?
Correct.
Okay. When you got there, was the vehicle running?
Yes, it was.
All right, what did you do when you first arrived and observed the vehicle?
I walked up to the driver's side window. Mr. Geiger had told me that the homeowner's name was Daniel, and I saw someone in the car, and I spoke his name and said, Daniel. He didn't know there was no response. And I got a little closer and found that the driver's side window was broken kind of at an angle. Some of the glass was in, some had come out, but there was also a small rounded spot in that glass that was still in there. I said, Daniel, again, no response. He was slumped over and kind of gasping for air, and it was just a sucking sound. I noticed that he had a set of eyeglasses. Half of a set of eyeglasses was laying in his lap. He had a cell phone in his left hand. He had a business card in his right hand. I walked around to the other side of the car. Well, first I reached in and unlocked the door, and I went around to the other side, and I opened the door and reached in and shut off the car, so the car wasn't still running. And then I noticed the other half of the eyeglasses laying on the floorboard of the car. I
Let me
removed
pause you there and approach and show you what I marked as states 8 through 10.
Yes. Yes.
Are these 3 photographs fair and accurate representations of how the vehicle appeared that day?
Yes.
Okay, Judge, I'd ask to introduce states 8 through 10. No objection.
States 8 through 10 are admitted.
Publish 8, please. All right, can you, got a pointer, show us what you're talking about as far as the way the window was?
Part of it had broken out, part of it was still intact, but right there looked like a little rounded area.
All right, and was this void, large void that we see in the window there before the door was opened?
Yes, yes.
Okay, so you said you were able to reach in and unlock.
Yeah, I
the
reached
car.
in, the door was closed, I reached in through that broken area, unlocked the car, and then ran around and entered from the other side to pull out, turn off the car and pull out the keys.
All right, and during this time, was EMS already en route?
Yeah, I could hear them. I could hear them coming down the street. They were almost there.
Okay, and were life-saving efforts made to try to help Mr. Markel?
Yes, when I was on the passenger side, I pulled out a gym bag or something that was in there and pulled it out and set it on the ground so they could make better entry into the vehicle to extract him.
Okay. And did he ever regain consciousness or say anything during the time you were
Not
there?
in my presence.
All right. Publish 9, please. Publish 10, please. All right. Do you see the half part of the eyeglasses there in that photograph?
Yes.
Could you indicate with your pointer?
Yeah, right there.
And is that where you observed them, or had they fallen out?
They had fallen out. One was in his lap, and then one was on the floorboard on the driver's side.
All right. And what about the cell phone that we see pictured to the left of the eyeglasses?
That was in his left hand.
Was there a safety search done of the house?
Yes, after EMS was removing him, then myself and a couple other officers, we took the keys that were in the car. The person door from the garage into the house was locked. We unlocked that, did a search of the house, found no one, nothing amiss.
Any indication that this was a burglary, a robbery?
No,
Any obvious signs of a struggle?
no.
No further questions.
Cross-examination for Mr. Sims. You may step down, Mr. Sims.
This
Yes.
witness is released, Your Honor.
Thank you. Please call your next witness.
Joanne Maltese.
raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
You may take your seat. Please speak loudly and clearly for the jurors.
Please introduce yourself and spell your name.
My name is Joanne Maltese. Joanne, Joanne, and Maltese, Maltese.
Are you employed, ma'am?
Yes, I am.
Are you employed as law enforcement, in law enforcement?
I am retired Tallahassee Police Forensic Specialist.
How long have you been retired from, it's Tallahassee Police Department, right?
Yes, a little over 8 years.
What were your duties when you were employed there?
Duties as a forensic specialist is the documentation, collection, and preservation of evidence at a crime scene.
How long did you do that type of work?
Done that work for probably 15 years.
Okay. And were you doing it back on July 18th of 2014?
Yes.
As part of your job, did you respond to 2116 Trescott Drive on that date?
Yes, I did.
All right. And what was your job once you arrived at that particular scene?
That particular day, I was called to document and collect evidence at a crime scene.
Publish 10, please. Is this the scene that you're referencing?
Yes, it is.
All right, I'm going to approach and show you states 11 through 17 as well. Just have you look through those and tell me if you recognize them.
Yes, I do.
How do you recognize them?
I took these photographs at the scene.
All right, Judge, at this time I'd ask to move into evidence states 11 through 17.
11 through 17 are admitted.
Publish 11, please. Publish 12, please. Did you collect the eyeglasses shown in State's Exhibit 12?
Yes, I did.
That appears to be half of a pair of eyeglasses. Did you collect both halves?
Yes, I did.
I'll show you what I've marked as states 121 and 122. Do you recognize those?
Yes, I do.
Are those the two halves of eyeglasses collected from this crime scene?
Yes, they are.
Judge, at this time I'd ask to move into evidence states 122 and 123.
Any objection?
There you are.
States 122 and 123 are admitted.
Publish the next exhibit, please. Did you collect this eyeglass lens?
Yes, I did.
Where was it located?
I believe that one was the floorboard of the driver's area.
Was there another piece of eyeglass lens also collected by
Yes,
you
there
that
was.
day?
Yes, there was.
Okay, where was that piece found?
That was, the other optical was on the driveway, or I'm sorry, the garage floor right below the driver's area.
Showing you 123 and 124. Are these the two pieces of lens that you collected that day?
Yes.
Move into evidence 123 and 124.
Any objection?
There you are.
States 123 and 124 are admitted.
Did you take any swabs or attempt to get any fingerprints from the scene?
Yes, I did.
And what efforts were made on those fronts?
I processed the entire exterior of the vehicle for fingerprints. There was an area that was lifted, but it did not have fingerprints of value to compare. As far as the swabbing, all of the exterior and interior door handles, as well as a phone that was collected, and the doorknob from the garage to the interior of the house.
And what were the results of those efforts?
Those I would not know. It'd be sent to FDLE lab for analysis.
Did you find any fingerprints of value to send to FDLE lab?
No, I did not.
Publish states 14, please. Approaching with states 125. Do you recognize 125?
Yes, I do.
What is this item?
This is going to be a brown wallet with its contents that were found in the glove box of the vehicle.
All right, and did the wallet contain Dan Markel's driver's license?
Yes, it did.
And in the exhibit, there's no cash, but there's some cash pictured in the photograph.
Yes.
Was there cash that was seized as well?
Yes, there was.
All right, so based on this, didn't appear there was any effort to take Mr. Markel's belongings.
Correct.
Okay, any evidence that the house was broken into or anything was taken from the house?
Not that I could determine.
Publish states 16, please. And 17. And then back to 16 if you would. What efforts were made to document this? What is it that we're looking at?
We're looking at the front driver's door window that was shattered with a hole in it.
Okay. And what did you do to try to document this?
The glass was very fragile because it was broken, so prior to doing anything to it besides fingerprinting, I would have put clear tape on both sides, the interior and the exterior, just to hold it in place for transportation and collection.
I'm approaching with what I've marked as states 126. Is this the glass that you were able to remove from the vehicle?
Yes.
Is it in the same or substantially the same condition as when you seized it?
Yes.
Move into evidence states 126.
Any objection?
No, Your Honor.
States 126 is admitted.
I publish. And the glass evidence, is that consistent with a gunshot?
Yes, it is.
All right, did you, as part of your job, have an occasion to photograph Wendy Adelson's vehicle?
Yes, I did.
Was that done the same day that you collected this other evidence?
Yes, it was.
Where did you photograph her vehicle?
Her vehicle was towed to the Tallahassee Police Department.
I'm going to approach and show you what I've marked as states exhibits 18 through 21. Do you recognize 18 through 21?
Yes, I do.
Are those the photos you took of Ms. Adelson's vehicle?
Yes.
Move into evidence 18 through 21.
Any objection?
No, Your Honor.
States 18 through 21 is admitted.
Publish states 18, please. Publish 19. Publish 20. What is this item?
This was on the front passenger seat of the vehicle, and it is a bottle of alcohol and a receipt.
All right, and did you take a closer photo of the receipt? States 21, please.
Yes.
And what does that show about when the alcohol was purchased?
On 7/18 of 2014 at 12:49 from ABC Fine Liquor and Spirits, or Fine Wine and Spirits.
Did you also go to the hospital?
Yes, I did.
What were you asked to do at the hospital?
Document and collect any evidence.
At the time that you responded to the hospital, was Mr. Markel deceased or still alive?
He was still alive.
I'm going to approach and show you what I've marked as states exhibits 22 through 24. Do you recognize these exhibits?
Yes, I do.
How do you recognize them?
I took those photographs at the hospital.
Are they fair and accurate photos of how Mr. Markel looked that day?
Yes.
Move into evidence, State's Exhibits 22, 23, and 24, Your Honor.
Any objection?
No, Your Honor.
States 22, 23, and 24 are admitted.
Publish 22, please. This is how Mr. Markel appeared,
Yes.
and this was done on the 18th.
Yes. Yes.
Publish the next exhibit, please. This is 23. Why did you take this photograph?
For the darkened area on his forearm.
Why was that of significance?
That is consistent with stippling.
What is stippling?
Stippling is being close contact to a firearm that was discharged, and it's going to be the unburnt gunpowder and gases that leave the barrel of a gun at a high velocity, and it will tattoo or stain the skin.
State's Exhibit 24, please. Is this another effort to capture that stippling that you observed?
Yes.
No further questions.
Cross-examination.
No questions, Your Honor.
Very well. Ms. Maltese, you may step down.
This witness is excused, Your Honor.
Please call your next witness.
The state calls Dr. Clark.
Dr. Clark, please raise your right hand, sir. Do you swear or affirm the testimony you're about to provide will be the truth?
Yes, I do.
You may take your seat.
Thank you.
Please speak loudly and clearly.
Sir, please introduce yourself and spell your name.
I'm Dr. Anthony J. Clark, A-N-T-H-O-N-Y, J. Clark, C-L-A-R-K.
How are you employed?
I'm currently employed as Associate Medical Examiner for the Georgia Bureau of Investigation, Division of Forensic Science in the Central Regional Office in Macon, Georgia.
What are your duties there?
I work as an Associate Medical Examiner. I perform what's called the autopsy and forensic autopsies and death investigations.
Was there ever a time that you worked here in Tallahassee as an assistant medical examiner?
Yes.
What time periods did you do that?
It was from 2007 to 2023.
All right, and how many autopsies have you performed during the course of your career?
It's over 8,000 now.
And what is the education and training that you have that qualifies you to do that type of work?
I obtained my Bachelor of Science degree from the Massachusetts Institute of Technology. I did 2 years of animal research before moving on to Jefferson Medical College in Philadelphia. I graduated from the college and then traveled over to New Britain General Hospital in New Britain, Connecticut, and did a 2-year general surgical internship. I then went to the Hartford Hospital in Hartford, Connecticut, and did 4 years of anatomic and clinical pathology. I then traveled from that program down to Atlanta, Georgia, where I did a 2-year forensic pathology fellowship at the Fulton County Medical Examiner's Office in association with Emory University. I am board certified in anatomic and forensic pathology. I have medical licensures both in the state of Georgia and Florida.
Have you ever testified as an expert in the area of forensic pathology?
Yes, I have.
How many times?
Several hundred times.
Tender Dr. Clark as an expert in the area of forensic pathology, Your Honor.
Does the defense wish to voir dire the witness?
No, Your Honor.
Is there any challenge to his ability to provide an opinion?
No, Your Honor.
Members of the jury, the witness will be permitted to testify before you today in the form of an opinion in the fields of both medicine and forensic pathology. You may continue.
Doctor, did you conduct the autopsy of Dan Markel?
Yes, I did.
When was that conducted?
We performed it on July 19, 2014, and we started at 11:55 hours.
Where was the autopsy conducted?
At that time, we were in the Tallahassee Memorial Hospital morgue.
Did you take photos as part of your autopsy?
Yes, I did.
Would use of those photos assist you in your testimony?
Yes, they would.
Would they assist the jury in understanding your testimony?
Yes, they would.
Approaching the states 25 through 34. Take a moment to look through those and let me know if you recognize them.
Yes, ma'am.
Are they fair and accurate photographs that were taken during the autopsy of Mr. Markel?
Yes, they are.
Moving to evidence states 25 through 34, Your Honor.
Any objection?
No, Your Honor.
States 25 through 34 admitted at this time.
Publish 25, please.
Before you publish, if the parties can briefly approach.
Yes, sir.
A brief break before we continue with the examination of Dr. Clark. The bailiff will take you to the jury room. Seated. Mr. Zelman, Ms. Fulford, if your client needs to use the restroom, this would be a good time to do so. still going to the bathroom? Checking on them. Okay. State, you may resume with your examination of Dr. Clark at this time.
Publishing 25. And doctor, you should have a pointer. All right, explain what we're looking at in states 25.
As part of the examination, particularly in gunshot wounds, we like to know whether the bullets are still in the body or how badly they are broken up, etc. So we do X-rays, and this is an X-ray of the head. You can see the top of the head here, the jaw, right side, left side, and these really bright spots here and here are the bullets that we recovered from this individual. They come out because they're very dense. The X-rays bounce off and turn them white here, just like bone. It's fairly dense. These are the bullets here, here, and here.
Publish states 26, please. How many bullets were in Mr. Markel's head?
There were 2 bullets in his head, and you can see on this one here that hit the left cheek, actually fragmented a little bit. And then we had a bullet inside the head, back to the left side. Right side, excuse me, right side.
States 27. What are we looking at here, doctor?
This is actually the identification photograph of the individual. We like to get them cleaned up. We'll put the identifying tag underneath their chin, the case number, the date, and usually my initials. And you can see that there has been quite a bit of damage here, particularly in the left side of the face. We have a gunshot wound here that's labeled number 1 in the autopsy report, and this is number 2, labeled number 2 in the autopsy report.
By labeling them 1 and 2 respectively, are you opining that that's the order in which those shots were fired?
No, the numbering system in the autopsy report is just for me to discuss during the trial.
Publish 28, please. What does 28 show?
So this is what I call gunshot wound number 2. And you can see it's quite irregular. It's not a nice round hole you'd like to see, but the way it hit the bone, it caused a lot of damage and tearing in this area here. You can see that there's some what we call raccoon eyes or hemorrhage around the eyes and quite a bit of swelling going on here. Also in this area here, you see a lot of minor superficial abrasions that vary in size. Some are much bigger and some are much smaller. You can see it's all over the cheek here, so, and the ear, and in the side of the neck here. This is what we call pseudo-stippling, and this usually happens after the bullet goes through a door or a window or hits concrete and causes those items, the glass or the wood or the concrete, to splinter and cause small particles to fall out, to shoot out and hit the individual's skin. So this isn't true stippling, which is due to gunpowder, and we'll see an example of that in a minute. But so we have large areas of pseudo-stippling around the left side of the face and left side of the neck and ear.
So each of those small red injuries represents a piece of glass striking?
Piece of glass, yes ma'am, or part of the bullet that fragmented off the main part of the bullet.
States 29, please. What does this one show?
Again, we're looking at the left side of the neck here. Here's the left ear. You can see that this pseudo-stippling is quite extensive. Also, you'll see that there's kind of a purplish discoloration here. Because of where the bullet track went to, it caused a large amount of bleeding into the left side of the face, where you saw a huge distortion of the left side of the face, and then drain down into the neck.
States 30.
Okay, this is going to be gunshot wound number 1. It's right between the eyebrows, closer to the left eyebrow. Again, it is distorted, it's not a nice little round hole because of the shelf of bone that's there. It's called the glabella. So it causes an irregular entry wound. And now we're seeing a much finer area of stippling across the forehead here. This is much different from what we're seeing on the left side of the face. This is true stippling or gunpowder stippling from the barrel of the gun directly.
How does firing a gun cause this pseudo-stippling?
The stippling.
Sorry, stippling.
Okay, when the firearm is discharged, out of the barrel comes the bullet, of course, hot gases, soot, burning and unburned gunpowder. What causes the stippling is the burning and unburned gunpowder. It actually it's a particulate that strikes the skin and abrades it. It doesn't burn it, but it hits it and abrades it, or scrapes it. So that usually with a handgun, we can see the stippling out to about 18 to 24 inches. This to me looks a lot closer than that, but all we're seeing is the stippling here.
So the presence of this evidence suggests that the muzzle of the gun was quite close to Mr. Markel's head when it was fired.
Yes, I'm thinking inches. Yes, ma'am.
States 31, please. What does this show?
Okay, this is giving you a perspective of the two gunshot wounds here. What I call labels 1, what is label 2, the pseudo stippling on the nose, the fine stippling on the forehead, the hemorrhage around the left eye, part of the raccoon eye pattern.
States Exhibit 32.
This is the left forearm, and what you see here is kind of a ring of soot, partial ring of soot here, and some stippling on the forearm here too.
What is that consistent with?
That to me is suggested that that arm was up near the gun when it was discharged. That's at one point in time, and most likely the one gunshot wound that went to the center of the head here, that arm was up in a defensive type thing or a reaction type thing, and the soot and stippling is actually not from the barrel, but when you're talking about a revolver, you have a cylinder where the bullets are, you have a space between the cylinder and the barrel. It's called a cylinder gap. And soot and gunpowder can come out of the cylinder gap and cause this kind of pattern.
So again, consistent with the firearm being very close to the victim?
That's correct.
And also, is it consistent with the victim at least having enough wherewithal of the impending danger to raise his arm in defense?
In my opinion, yes, ma'am.
Right, and you said that the number that you order the shots for purposes of your reports does not necessarily mean that's the order of the shots that were fired in this case. Do you have an opinion as to which shots were fired in what order?
Yes, after discussions with the investigators and looking at the scene photographs, the first shot went through the closed car window. So the first shot would have been to the left cheek area, which traveled from the left cheek just before the left ear, hitting soft tissues, fracturing the jaw, fracturing the left cheek bone. Again, this is maybe slightly incapacitating, maybe stunned him, but would not immediately put his lights out. Okay, so that is where all the pseudo stippling is coming from that glass shattering. Glass is not there anymore. The second shot is to the forehead, where the actual gunpowder can strike the skin, and the hand was raised somehow into the vicinity of that cylinder gap.
And that's the second shot, is the one that was not survivable?
That's correct.
And was there any amount of medical attention that could have assisted Mr. Markel, say if it had gotten there sooner?
Well, these are pretty devastating injuries, particularly the gunshot wound in the brain.
Did you collect the projectiles from Mr. Markel's head?
Yes, I did.
I'm going to show you States Exhibit 127 and 128. If you will publish 33, please. Ask if you recognize 127 and 128.
Yes, I do.
How do you recognize those?
These are the envelopes that we placed these bullets in with the identifying marker labels and where they were from. Both one's from gunshot wound number 1 and one's from gunshot wound number 2.
Are they in the same or substantially the same condition as when you collected them?
They appear to be so, yes, ma'am.
Move into evidence 127 and 128, Your Honor.
States 127 and 128 are admitted.
And is Is this a photograph of one of these projectiles removed from Mr. Markel's head?
Yes, ma'am. This is the one from gunshot wound number 2 to the left cheek area. If you remember on the x-ray, it had kind of a barrel shape to it. I don't remember, but you see the barrel shape here.
And for the record, that was 33, now publishing 34. What does this show?
This
Would
is
you be able to turn it? Upper left, maybe? Again. Thank you. What does
this
this
is the
show?
bullet that we pulled from the right side of the brain. On the x-ray is getting a little pretty deformed. You can see that we've taken one picture, one aspect of it here. Here's the identifying label.
What is meant by the term cause of death?
That is how that person died.
All right, and is it part of your job as assistant medical examiner to determine a cause of death?
Yes, ma'am.
And were you able to do that in this case?
What
What was the cause of death?
gunshot wounds of the face and head.
And what about manner of death? What's meant by that term?
Manner of death is how what were the circumstances that eventually led to the death.
And do you have an opinion as to the manner of death?
Yes, I do.
And what is it?
Homicide.
No further questions.
Cross-examination, Dr. Clark.
No, Your Honor.
Judge, this witness can be excused, and this might be a good time to take our lunch recess.
Very well. Dr. Clark, you may step down, sir. Have a good day. Members of the jury, we are going to take our lunch break at this point. As you have been previously instructed, I'm just going to remind you again, you are not to discuss this case with each other or any other person. During your lunch break, you may eat together if you choose to. Again, you may converse about any manner of things, but this case. Does everyone understand this instruction? Please raise your hands. And for the record, the jurors have raised their hands. Please return at 1:15. Enjoy your lunch break. Before we go on the recess break this afternoon, I do believe this merits a small bit of discussion on the topic. The matters that we've discussed at sidebar concerning emotional responses, I do feel it is important at this point. Mrs. Adelson, when the testimony is occurring or the evidence, I know you may have a natural reaction, but as best possible, you need to control your reactions concerning any head movements, any expressions of disagreement, or any emotional outbursts. The jury must decide this matter on the merits, on the evidence. Do you understand this? Very well. I do not wish to do this in front of the jurors at all, but it's very important that you are able to control your emotions. Do you understand what I'm saying? Does either party need to be heard before we before we go into the lunch break?
No, Your Honor.
No, Your Honor.
All right, please report back at 1:15 as well. I believe we have 3 other witnesses that we can possibly get through this afternoon. That's fine. Go ahead.
To break, the defense advised they've got some objections to my exhibit that I intend to introduce with this next witness. State's Exhibit 64 is email exhibit. It's a composite. And I haven't had time to look at all of the ones they're objecting to, but I know the first one is marked as State's Exhibit 64A. Yeah, Coach.
You may.
This is an email initially from Donna Adelson to Wendy Adelson, and Wendy replied March 28, 2011. It includes content in paragraph 3, which is a discussion of Dan and his parents attempting to spend time with the kids and how annoying that is to Mrs. Adelson. You can read what it says. Defense is objecting to that item. On relevance grounds, relevance is that Mrs. Adelson hated the victim and that hatred extended to his parents as well.
Ms. Fulford?
This is while they're still together, Judge. This is 2011. It has nothing to do with Danny. It was a derogatory comment made by my client regarding Danny's parents. Wendy made comments and Mrs. Adelson made comments, and they're not relevant to this case. This is while Danny and Wendy are still together.
As to whether your client had any animus towards the deceased, is there a time period where it has to be within the divorce?
It's not animus towards the deceased. I'm talking about the comments towards his parents.
Kappelman, as it relates to the comments going towards the parents.
I think it's relevant, Judge. Goes toward motive. She did not want these children to be with the father and with the father's family. She wanted them with her and her family. And that's what happened.
That's not what this email says.
Right. No, it's not what the email said. It's not a confession of murder. It's a expression of dislike, which just goes to the motive.
All right. Much of this email does lack relevance or probative value for the jury. However, Ms. Kappelman, does this tie into other messages which otherwise would demonstrate the motive you're trying to prove? Or is this a standalone item?
I mean, there are other emails that express similar sentiments. I don't think they're specifically tied to the visit that's referenced in that particular email.
Are you arguing then that the defendant had a consistent animus towards the deceased?
Oh, yes.
Very well. Over objection, I will permit it only on the grounds that it shows that the defendant had a consistent animus towards the deceased or his family. However, If the defense is asking for a limiting instruction as to this evidence, you may request it now.
If we're asking, yes, we would ask for a limiting instruction. This is not directed towards Danny Markel. I mean, if you take a look at it, Mrs. Adelson is complaining that Danny and Wendy have to schlep the boys down to see his parents instead of them driving up to see the boys. It has nothing to do with trying to keep the boys from the family. So I'm not sure what limiting instruction would be effective, but this is as to, it doesn't express any animus to Danny. So I'm not sure what the court would suggest.
Or his family.
The state's theory is not hatred towards the Danny Markel's family. And so I'm
Ms. Kaplan,
confused.
as to the state's theory, please clarify this issue.
State's theory includes that Mrs. Adelson hated all things Dan Markel, and all things Dan Markel needed to be erased from these children's lives, including the grandparents. Now, I know Your Honor has precluded me from mentioning visitation with the grandparents and things like that, but obviously that's always been a part of the state's theory. I understand that I'm limited from including that, but it is important to show that this animus existed as far back as 3/28 of 11. And this is the first item in the exhibit because it goes back the furthest in time. I think it's important.
We're not going to be wasting a lot of time on this back and forth. This is the point of pretrial motions. On this point, as it relates to the state's theory of the case, that the defendant had animus towards the deceased or his family, it will be permitted on those grounds. If the defense is asking in some way for a limiting instruction to be given, please request it now.
Yes, Your Honor.
What is the limiting instruction that is requested?
Your Honor, I'm at a loss. I think that an instruction that, I mean, this doesn't show hatred towards Danny. So again, I'm not sure. Obviously, I disagree with the state's argument concerning this. So I'm open to suggestions.
Be considered for the defendant's state of mind as it related to the deceased or his family.
I would ask that it be related to the deceased's family. Because it's not to do with the deceased.
Ms. Kaplan. Very well. Down.
There's 5 more items, Judge.
Let's go through them.
Yes, sir. State's Exhibit 64D is an email dated 10/26/12. May I approach?
You may.
This email is from Donna Adelson to Wendy Adelson, showing her a list of prospective love interests from a website that Mrs. Adelson has identified as potential matches for Wendy. It's offered to show how controlling Donna Adelson was over her children's lives, how much she inserted herself into their private lives, and again, she likes to be in control of who they date and who they marry.
Response.
Judge, this is not an email from my client, Wendy Adelson. This is an email from Match.com to the email address that my client has. It doesn't say anything, the copy I have at least, doesn't say anything at all about Wendy Adelson.
Okay, I'll replace it with a copy that shows the email heading on the top, Judge. It's my fault.
And this was her forwarding this or actually including some sort of message?
She forwards it. I'm not sure if she included a message. She definitely did on the next one, which is also subject to defense objection. It's State's Exhibit 64I. I'll approach with that as well. Related.
What's the date on that?
What's the date on that, Mr. Kaplan?
1/17/13 is the date on Exhibit 64I.
As to any questioning of Wendy Adelson as the role her mother played in her life, including screening potential romantic interest, that question certainly can be asked, but as to an exception to hearsay, what is being offered concerning this?
The relevance of it, or
Yeah.
the exception to hearsay is
Let's
it's
go
a statement
through
of a
both.
party. Relevance is that Mrs. Adelson was very controlling and micromanaging in her children's lives, particularly in their love lives, which directly relates to the motive to this offense.
Right.
Eliminated Mr. Markel. You get it, you get the idea.
I just can't understand how this would be material to this case in any way, anything that the state has to prove. That, you know, it's not, we just want to bash her reputation or what she did. They got to prove criminal offenses against her. How does her being on Match.com while she's living with her daughter have anything to do with something the state has to prove here? Nothing.
I believe this once again goes to the issue of motive. I understand the defense's position that you disagree. As to this motion, or excuse me, as to this item, this is you said 64I.
64D and I, Your Honor.
Right. As to whether the defendant in any way possessed a motive concerning Wendy Adelson, or excuse me, as it related to the deceased in controlling who Wendy Adelson may have sought as a romantic interest. Ms. Kappelman, do you have other evidence that's going to tie that to this particular item?
I do have other evidence that Mrs. Adelson was just on the wire speaking about Wendy's love life and her current love interest and who she wants her to date and discussing with Charlie Adelson, wanting Charlie to intervene with Wendy and encourage her to date a certain person. So I do think it is a theme that reemerges with other evidence.
Well, as the state of mind and motive, I will permit this evidence to be given over objection. However, as to the foundations for these things, Ms. Kappelman, they'll have to be laid through the appropriate witnesses.
Okay, all these items came from a search warrant executed on Wendy Adelson's Google account. The next item, Judge, is just a moment to locate this. I believe it's 64W, an email dated June 27th of 13. And the objection in this case relates to the characterization of Judge Hobbs as a, can't find the quote, but something like a Southern black lady. They just were proposing redacting that. Find the page for Your Honor. It's mostly redacted, so. It's page 2 of that email. I'll give you 1 and 2. Second page 2/3 of the way down in the second paragraph, mention of Judge Hobbs. There's no particular relevance to that characterization of Judge Hobbs, so I just don't think it's prejudicial, so I don't know why we're redacting. Whatever Your Honor thinks on that one, Judge.
Folks,
I believe the jury could take that as in a very derogatory way. It has absolutely nothing to do with this case, that comment. Nothing. Unless there's another motive I don't know about.
if in some way, since we do have two jurors of African American descent that would otherwise impute on the defendant a negative character trait, I will permit the redaction for that reason. Beyond that, the item will be admitted.
Next, Judge, is an email dated April 7th, 2015. I believe what's referenced here is 64HH. Yes, sir. May I approach?
You may.
May I have the other exhibit? Judge, this email is an email regarding Wendy moving, and the evidence is going to show that she moved from a more secure location to a less secure location, so the relevance is sort of going to have to be developed as the trial goes on, but the idea is that there was no fear for Wendy's safety.
What's the date?
That email is dated,
7/15, I believe, is the last date in the chain.
thank you.
If you have to start the foundation with one witness but enter at a later point, that is certainly appropriate. What is the objection?
Well, Judge, I have a question. The email that I'm looking at that was provided to us on July the 15th, 2014 is to Jennifer Koss from Wendy Adelson.
I believe these are from David Trafton at MiamiRealEstate.com.
That's not what we were given.
May I show the exhibit to the defense?
Please do.
Email that we've been handed, it's April 7th, 2015, 4:42 p.m. This is regarding Wendy moving. It had the same security as where she was living with her mother, so less secure. There's nothing in here that indicates that.
I'm going to ask Ms. Adelson about that. My understanding is it is less secure. They're asking lots of questions, but they're not about security, but if they're being actively extorted under threat for their lives, one would expect and would inquire about such a thing.
You may lay the foundation, or at least begin to lay the foundation for that item with when that witness is examined. Going back to the last trial in this matter, when the intent instruction was given, the intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case. Specifically, as counts 2 and count 1 that are charged in the indictment deal with aspects of intent. I'm going to find evidence that demonstrates the defendant's alleged motive, which goes specifically to intent, is admissible. One thing, though, that is starting to trouble me with this, we had many motion hearings in this matter, and we've continued this case several times to handle these matters pre-trial. Why is this coming up now?
The exhibit that we were provided with, I went through thoroughly and had all of my objections listed, and then was told that's not correct. It's another binder. It's different emails. The binder I was handed by the state was completely discombobulated, not in date order. It was a train wreck.
As the state's exhibits you're referring to.
That's correct. And so then they provided us with this binder. It appears to maybe still be missing something, but they have a list, an exhibit list, everything laid out by date, by exhibit A, all the sub-exhibit numbers. So that's why, Your Honor.
We're not going to waste the jurors' times. At this point, we're 30 minutes behind where we should have been. Are there any other matters that need to be addressed?
There's one more that I asked for, Judge. It's dated April the 20th of 2016, and it's an email about whether one of the children is sad.
64II, Judge, is an email specifically in which the defendant is claiming that the child cannot be sad about the death of his father. Extremely relevant.
Its probative value is outweighed by the undue prejudice, Your Honor.
Compliment again, the purpose this is being offered for is going to motive or state of mind.
Yes, Your Honor.
What is the undue prejudice that the defense is arguing concerning this particular email?
The undue prejudice is what the state is arguing, and they're going to argue to the jury, is that this email says that Donna Adelson said he could not be sad about his father. What she's describing is her time with the child, and she hasn't seen him sad. And it's 2 years after, unfortunately, Mr. Markel was killed.
Ms. Kettleman, if you wish to proffer the testimony from the witness on this, I'll allow you to do so in the presence of the jury, but this one is seeming a bit attenuated.
Mrs. Adelson.
In commenting on how the child is said.
Sure, Judge, but it relates back to the motive in thinking that it wouldn't harm the children. It was going to be good for the children. to get rid of their father. Children have no memory prior to this young age that the father was killed. I think it goes to motive, Judge.
That, I'll allow you to set up your foundation within parts if you need to do so. I'll revisit whether this item can be admitted at that point.
Alright, sir, there's one item that I've added today in light of the opening statement regarding Mrs. Adelson's use of the Skype to facilitate visitation with the father. It's dated December 18th, 2013. It has been previously provided. It's now marked as State's Exhibit AA.1. While the defense is looking that over, I also have a stipulation of the parties may I approach.
Right.
This will be the first thing. I'd like to have your honor read this to the jury as soon as they come back in. Sorry, Judge, I've handed them the wrong thing. I'm gonna have to circle back to that. With that, stipulation, we're ready. There's no other issues.
Right, as to 64, I believe D and I did rule over motion that these can be admitted with a proper foundation. As to I believe that's the item that the state is going to, 64II, I should say, that's the item the state is going to attempt to lay the foundation for as it relates to motive in this matter.
Yes, sir, I found the relevant portion. It reads from Donna to Wendy here. I'm sorry, from Wendy to Donna. Dear Mom and Dad, here is the phone/Skype plan for the holidays. And she's forwarding a Skype plan from Dan Markel. Please help me do this. It means less stress for me if we just follow it.
I don't know what the relevance of that is. Wendy Adelson sending an email to her mother because her mother takes care of the children very frequently and saying, here's the schedule, let's do this. It doesn't say Mrs. Adelson has not done it.
I think it suggests that Mrs. Adelson has not done it, or at least that there's been issues and problems with Skype and facilitating Skype satisfactory to Mr. Markel. So I would ask to admit it based on the statements made in opening statement by the defense.
The opening statement is not evidence. The jurors are not considered as such. As to any foundation that you wish to lay for that particular item, that it was not previously followed, and now Wendy Adelson sent that item to her mother, you'll need to establish the foundation first before it's offered. Please bring in the jurors. And I are offered, the limited instruction will be given.
Thank you, Your Honor.
Everyone can be seated. Members of the jury, I trust you had a restful lunch break. Before we resume with the evidence this afternoon, I'm going to read to you a stipulation that has been agreed upon by the parties. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is the projectiles contained in State's Exhibits 122 and 123 were examined microscopically by a firearms expert from the Florida Department of Law Enforcement and were determined to have been fired from the same revolver. Ms. Kappelman, you may call your next witness.
Thank you, Judge. The state calls Craig Isom.
Please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. Please speak loudly and clearly for the jurors.
Please introduce yourself and spell your name.
Craig Isom, C-R-A-I-G, I-S-O-M.
How are you employed?
I'm currently retired,
Congratulations. Where did you work when you worked?
sent to Tallahassee Police Department,
How long were you with the Tallahassee Police Department?
28 and a half years.
Were you assigned to investigate the murder of Dan Markel?
I was.
How long did Dan Markel live after being shot?
I believe my understanding was around approximately 11 hours.
As part of your investigation, were the people closest to the victim interviewed,
Yes,
including his ex-wife, Wendy Adelson?
yes.
When and where did you approach Wendy Adelson?
She was at a restaurant in Tallahassee on Market Street.
What date and time did you approach her at the restaurant?
That was on the day of the shooting, which was July 18th, 2014. July 18th, 2014. It was approximately 2:15 in the afternoon.
All right, so approximately 3 hours and 15 minutes after the shooting?
Approximately, yes.
What did you say when you approached her?
I told her that I needed to discuss something with her in private. She was with two other individuals at the table.
Two ladies having lunch?
3 total, yes.
All right, and when you told her that you need to speak with her, were you wearing police insignia? Did you identify yourself as law enforcement?
Immediately before I identified myself and said that I was there for the purpose of speaking with Wendy Adelson.
Okay.
And I had my badge on. I was readily identifiable as a police officer.
All right, and did you reassure her that she wasn't in any trouble? Did you?
Yes, I got her to step away from the table she was eating at, approximately 10, 15 feet out of earshot of the other two individuals that were sitting at the table. And I told her that I needed to discuss with her something that happened with her ex-husband and that her children were not involved. I reassured her because the children had already been checked on, they were still at the daycare, and they were fine.
As part of this approach of Wendy Adelson, were there any handcuffs involved?
No,
Any Miranda rights read?
no,
Any use of force at all?
no,
She was not detained or under arrest?
no,
At any time did you tell her she was a suspect in anything?
no,
Was she a suspect in anything at that moment?
no,
At any time during your interview, did you do anything that would treat her as a suspect?
no.
In fact, you told her several times in the interview that she was not a suspect, isn't that right?
I did?
Did you ever accuse her of anything?
No.
Did you provide her with a victim advocate?
Yes,
Is that something that your office typically does for next of kin when a tragedy has occurred?
Yes.
Did you allow her to access her phone during the interview?
Yes.
What did you learn about the victim's relationship with his ex-wife, Wendy Adelson?
They had gone through it and were still fighting in a contentious divorce
I'm going to show
regarding
you
child custody.
with child
Regarding
custody.
including child custody.
All right, I'm going to approach with state's demonstrative A. Have you had an opportunity to review this exhibit before today?
Yes.
What is that exhibit?
It's all of the filings from the divorce case between Wendy Adelson and Daniel Markel.
Starting with the petition for divorce and ending at the time of his death, is that right?
Correct.
And the filings in here, have you had an opportunity to review them?
Yes.
All right, and did this litigation include arguing over things so petty as a tennis racket?
It did.
Objection, Your Honor. Nothing's been entered into evidence, and we would object to a witness testifying to the contents of the file.
Overruled, the witness may testify concerning his personal knowledge of the investigation.
Thank you, Judge. As part of these proceedings, did Wendy Adelson seek to relocate with the children from Tallahassee to South Florida?
She did.
Did she say why she wanted to relocate to South Florida?
Objection, hearsay.
Staying, the answer would call for hearsay unless you have an exception.
I'm going to show you what I've marked as State's Exhibit 60. Have you had an opportunity to review State's Exhibit 60?
Yes.
Are those the portion of the divorce filings contained in State's Demonstrative A that can be directly linked to Donna Adelson?
Yes.
Meaning she saw those items.
Yes.
Objection, lack of foundation.
I believe that's what Ms. Kappelman is doing right now. Overruled. You may continue, Ms. Kappelman.
Move into evidence State 60, Your Honor.
Where's the clerk? Please be seated. What's that? You can step down, Mr. Isom. Please step outside the courtroom. Sure. All right. At this point, I'm nearing becoming inclined to send the jurors home for the day, as we are wasting a significant amount of time on matters that were either previously litigated or now are still being challenged for reasons that could have been handled out of court. Mr. Zelman, for any item that is being objected to with State 60 that you are claiming has no tie to your client's communications, you need to look through that binder now.
Judge, part of the objection that we're making concerning that is without laying the foundation through a witness with personal knowledge, there is no tie to my client. Anything, and specifically anything post-dissolution, so post July 31st of 2013 that's in here, there's no evidence.
I heard this argument previously.
Yes.
It has been ruled upon.
Yes.
At this point, if the state has multiple witnesses that the foundation can be laid through, your objection will be noted for the record, but we are going to move on. If you need to look through this binder to match it up with specific communications in which you believe no foundation can be laid, you'll need to take the time. But as far as wasting the jurors' time on this any further today, what else does the defense need to look through concerning these exhibits? Before we leave here today, if we need to go through every single state exhibit to deal with any objections concerning them, we will do so, however long that takes. But we're not going to be wasting the jurors' time.
Just a moment, Your Honor. to our objection concerning establishing the foundation for proving my client's knowledge, we're ready to proceed.
Concerning that, Ms. Kappelman, between former Detective Isom, Wendy Adelson, or any other witnesses, are you going to be establishing the foundation as to the defendant's knowledge or connection through multiple witnesses?
May I have a moment, please?
Go ahead.
Judge, I had not planned to do that. I provided this exhibit to the defense. I have not heard anything about an objection, so I had not planned to go through every single piece of paper with this witness. I can do that, but that is going to take some time. I will need a recess to prepare for that. I do have a list of how each piece of paper is related to the defendant, but this witness isn't prepared to go through every single piece of paper in this exhibit.
Are you requesting for me to send the jurors home for the day?
No. I think I've complied with the court's ruling, and I'm requesting that the exhibit be admitted pursuant to that, and we move on.
There does have to be a foundation as to the nexus between the defendant's either communications or actions and these pleadings. That was the ruling. For what was provided in discovery,
Is that something that needs to be done in front of the jury, Judge, or is that something we could tie up later and move on right now?
you can tie up later, but it will not be admitted until the foundation is tied up.
Okay, Judge, I think that would be my preference then.
Very well. Please bring the jurors up. Please direct Detective Isom to come back in and take the stand. Detective Isom, come back in. Everyone can be seated. You may continue your examination, Ms. Kappelman.
Thank you, Judge. I'm going to approach with State's Exhibit 64. Do you recognize State's 54?
Yes,
How do you recognize it?
these are the emails, I believe.
Take time.
I believe these are from Wendy Adelson's computer.
Was a search warrant issued to Wendy Adelson's Google account?
Yes.
And did we receive emails subject to that search warrant?
Yes.
And does State's Exhibit 64 contain fair and accurate copies of emails between Wendy Adelson and Donna Adelson?
Yes.
And if you'll turn to the yellow tab there. In particular, are you familiar with this email? And for the record, Judge, this is tab AA.
This is. Yes.
Is that an email that was sent from Wendy Adelson to Donna Adelson? On the bottom.
This is from Donna.
Well, okay. It starts out as something from Danny, right?
Right. Dan sends this email to Wendy,
Okay.
and it's
what is,
CC'd to another individual.
okay. And what does Wendy do with it?
She forwarded it to her mother.
Okay. And is the content of the email related to what we referred to as the grandma motion?
Yes.
What is the grandma motion?
This is where Dan Markel.
What is the objection?
First of all, lack of foundation, and it's hearsay at this point.
Overruled as to lack of foundation. The investigator may testify as to his personal knowledge of the investigation. Concerning hearsay, Ms. Kappelman.
Did Mrs. Adelson respond to this email?
Your Honor, been object again. Mrs.
One
Adelson.
moment. Members of the jury, the bailiff is in order to take a vote. Investigator Isom, if you could step down, please, sir. So, not to sound like a broken record, but that part where the jurors need to go home so the issues concerning these documents can be worked through. Concerning that, Mr. Zelman, what is your position?
Judge, I've said all along.
I know what your argument is, but as to the items that the state is seeking to admit today, are there going to be more challenges of this nature? If you have objections, I will rule on them. But we're not going to waste the jurors' time.
Judge, as to 64AA, my client and her husband shared an email address. There's no evidence as to who sent the response that the state is trying to get to.
How many parts of 64 is the defense objecting to? Capital. Concerning AA, does the foundation need to be laid amongst multiple witnesses, or is Detective Isom capable of doing this?
As far as to whom the email address belonged, that will have to be tied up with Wendy Adelson.
Well, is there any other parts of Exhibit 64 that need to be dealt with now while the jurors are out of the room? Please look through it.
Just AA, Your Honor.
Are there any other exhibits that pertain to Detective Isom that need to be dealt with while the jurors are out of the room?
Would you like to know what items I intend to introduce, Judge, through him?
Please, so we can handle these objections now, and there will not be a constant back and forth where the jurors need to leave the room.
Exhibit 55. Show that.
I think we stipulated for that.
Well, 60 is the divorce excerpts, which again, we're going to deal with separately. The email, 64, my understanding is we're going to deal with AA, and then the rest of it is going to come into evidence with this witness at this time. 65, Mr. Rivera's ticket, which is certified. 66, Garcia's ticket, which is certified. 67, Save Gas records with certification. 68, Adelson Institute records with certification.
Are there any objections by the defense that need to be handled out of the presence of the jury concerning these items?
No, Your Honor.
There's a couple more, Judge.
Go ahead.
89, Premiere video clips. 90, bus video clips. 119 is a thumb drive containing the raw data from Premiere, and 120 is a thumb drive containing the raw data from the bus.
No objections to those, Your Honor.
Please bring back in the detective. As to AA, whichever portion of the foundation you're capable of laying with the detective, you can at least start it with that. As to the rest of it, you can seek to admit it if the foundation can be laid without it, or without any other witnesses. Please bring back in the jurors. Everyone can be seated. You may continue with your examination of Mr. Isom as it relates to the foundation.
Mr. Isom, you, I believe, previously indicated that you reviewed the divorce file as part of your investigation.
Yes.
And that's the court file.
Yes.
All right, and as part of your investigation, did you review the emails that were subject to Wendy Adelson's Google search warrant?
Yes.
And in those emails, was there an email in which the contents of, well, let me ask you first about the motion. Did you review a motion where Dan Markel was seeking to restrict Donna Adelson's access to the children?
Yes, I did.
All right, and that motion was filed with the court?
Yes.
It was pending at the time of his death?
Yes.
And did you find in the emails any evidence that the contents of that motion were sent to Donna Adelson?
Yes.
And is that tab AA of State's Exhibit 64?
Yes.
And are the contents of that email substantially similar to the allegations made in the court filing?
Substantially, yes.
Okay. And what is the gist of what it is that Dan Markel is requesting?
He does not does not want Donna Adelson to have unsupervised contact with his children
Why not?
because of the statements that are made in here and that was shown in the court filing, that the children reflected that Grandma says you're stupid, Grandma says she hates you.
And
Judge, Isom, please do not read from any document that has not been admitted.
at this time, Judge, I would ask to admit State's Exhibit 64.
All parts or just the part that does not include AA?
Subject to tying up AA, I would seek to admit the whole thing.
States 64, any objection?
Just the objection previously made, Your Honor.
Concerning States 64, it will be admitted except for Part AA and any later foundation that needs to be addressed.
Did, in your review of these emails contained in State's Exhibit 64, the defendant, Donna Adelson, use any strong language against Dan Markel?
Yes.
Did she call him any names?
Yes.
I would ask you to review State's Exhibit 64, tab DD. Do you recognize that exhibit?
Yes.
What email is that?
This is from Donna to Wendy.
And does she call Dan any names in that email?
She calls him Elvis.
How about asshole?
I know it's in here.
Take your time. Have you ever seen an email where she called him an asshole?
I've seen an email, but I don't see it here.
Okay, let's move on.
Okay.
Tab M, please.
Emma?
M as in Mike.
M.
Did she, who, I guess tell us who it's to, who it's from, and the date, please.
It's from Donna to Wendy, March 6th, 2013.
Does she call Dan Markel any names in that email?
Yes, she does.
What names does she call him?
In this
Name.
in this particular email, after the first paragraph, it says that she calls him a major fucker.
Please refer to tab Q, a May 3rd of 13 email.
Yes,
Does that email, is it from Donna to Wendy?
it is.
And does it reference Wendy's relocation efforts?
Yes,
Does it indicate that Wendy's relocation efforts are extremely important to Donna Adelson?
yes,
Please reference tab V as in Victor, a June 25th email. Are you familiar with the court filing in which relocation was denied?
yes.
Do you know on which date relocation was denied?
June 20th, 2013.
So this is email on tab V as in Victor. Is it 5 days after relocation was denied?
It is June 26th, 2013.
Does Donna Adelson, the defendant, propose another plan to facilitate relocation in light of the court's ruling?
Yes,
So this is done after the court's ruling,
Correct.
and relocation is still being discussed.
Yes.
Okay, what does she suggest?
She suggests that the children between Wendy and Dan start attending, or her, at least the ruse of them going to a Christian church or a Catholic church.
And to take pictures of it and send it to Dan Markel, right?
Yes,
To strong arm him into agreeing to the relocation, right?
correct, coercion.
Did Donna Adelson, the defendant in this case, suggest a bribe to Dan Markel to cause him to allow these kids to be moved to South Florida?
Yes,
Draw your attention to tab W. What is the proposal in reference to this bribe?
$1 million.
$1 million.
Yes.
Okay? Were there any death benefits, any monies that were to be gained from the death of Dan Markel?
Yes,
Did he have a life insurance policy?
he did.
What was the amount of the life insurance policy?
One of them was for $2 million.
And a second one for $60,000?
$60,000 from a second one through the law school.
Were there any survivor benefits for these kids in the event of Dan's death?
There was
What are those?
$4,800 a month.
Who gets that money for the disbursement of the kids?
Wendy Adelson.
What about through his employment at FSU Law School? Did he have a pension there?
Got a pension, a deferred comp, 401k,
And an estate worth some money, right?
approximately $300,000.
What was the total value of Mr. Markel's estate?
2.7 million.
As part of your investigation, did you attempt to establish a timeline of the victim's activities prior to his murder?
Yes.
What did he do that day?
At 8:50 a.m., he dropped off his children at the preschool daycare on West Tharp Street. From there, he proceeded to go back across town to Premier Fitness Gym off of Village Square Boulevard.
Was there any surveillance at the gym?
Yes,
And was that collected by law enforcement?
it was.
All right. Judge, at this time, I'd ask to move into evidence, State's Exhibit 119, a thumb drive containing the surveillance collected from Premier Gym.
Any objection? There you are. States 119 is admitted.
And was the raw data or surveillance video collected from the gym compiled in a way that shows what it is we're looking for concerning Mr. Markel?
That's correct, yes.
Was that done in State's Exhibit 89?
I believe so.
All right, Judge, at this time, I'd ask to move into evidence, State's 89.
Any objection? There you are. States 89 is admitted.
Were you able to see on this gym surveillance video Mr. Markel's vehicle enter the parking lot of the gym?
Yes,
At what time does he enter the parking lot of the gym?
I
if
believe
you
it was
remember? 9:11 sound right?
9/11, yes.
And we're talking about AM, so you said he dropped the kids off at 8:50 and he arrives at the gym at 9:11?
8:50 a.m. is when he dropped the children off, and he signed them in at the daycare. And then at 9/11 is when you see his car enter the parking lot at Premier, all on July 18th, 2014.
And were you able to see anything sinister about the parking lot of Premier Gym on the morning of Mr. Markel's shooting?
Following Markel's car entering the lot, a short time later, a vehicle enters the lot that is similar in description from the next door witness, Mr. Geiger.
And what does the suspect vehicle do when Mr. Markel enters the gym?
It parks and no one gets out of the car.
How long does the suspect vehicle stay there while Mr. Markel's in the gym?
I don't recall the exact amount of time, but it's quite some time that the whole time he's in the gym, and even after he comes out, gets back in his car and leaves. That's when the car leaves at the same time.
All right, so the whole time he's in the gym doing his workout, this suspect Prius is in the parking lot.
Correct.
And when he comes out to leave and gets in his vehicle, what happens with the Prius then?
The Prius follows.
Judge, at this time, I would ask to introduce State's Exhibit 89. I'm sorry, I have introduced it. I'm asking to publish it at this time. Thank you. Is this black vehicle Mr. Markel's vehicle?
Yes, it's a black Honda four-door. Same car.
And that's Mr. Markel parking right there behind the flagpole.
That's correct.
What is this vehicle?
That will be the suspect vehicle,
And
green
is
Prius.
Okay, consistent with the description given by Mr. Geiger?
They said a light colored or silverish, and the car color is a silver pine mica.
Who's that in the blue circle?
That's Mr. Markel exiting his vehicle.
That's him in the red shirt?
That's correct. It's Mr. Markel entering Premier's main doors.
What do we see in this image?
I'm sorry.
What do we see in this portion of the tape?
That's the suspect vehicle, the Prius, driving through the parking lot.
At this point, is Mr. Markel inside the gym?
He's inside, yes. This is still in the front section where the car went from right to left.
This is still part of the Premier Gym parking lot?
Correct, yes. It's just the opposite, camera facing the opposite direction. It's the car reversing course coming back towards the front doors.
Yep. Okay, now what's the time on the video here?
I can't read 10:30. I think it
Okay.
says 10:38.
Is this Mr. Markel exiting the gym at this
He's
point?
exiting the Premier in the same door he came in. I'm sorry, it's 10:33 on the timestamp.
Thank you.
That's Mr. Markel making his way to the parking lot where his car is parked.
Once he gets in the car, does he sit there a few minutes, or is that at the front end?
I'm sorry?
Does he sit in his car for a few minutes at one point?
Just a short period of time. Then his car starts backing up.
Where's that?
That's him exiting.
And will we see the suspect vehicle pull out
It's coming
behind
from
him?
the back side. See it? Same suspect vehicle following the direction of Markel's car.
Right, and it exits the parking lot at 10:39 a.m.?
Yes.
Okay. And based on what would be the logical route from here to Mr. Markel's home, did you try to get some additional surveillance to see if you could catch the suspect vehicle any further?
Yes.
What was that?
That was, the location was the business, no, I'm sorry, it was the bus video off of a bus at McClay Commerce Boulevard and Thomasville Road.
All right. And were you able to actually find some bus video from both before and after the shooting of the suspect vehicle?
Yes.
Okay. And were those the raw data that you collected from the bus compiled into clips similar to what we saw on the gym video?
That's correct.
All right, Judge, at this time I would ask to move into evidence State's Exhibit 120, a thumb drive containing the bus raw data, and State's Exhibit 90, a disc containing the bus video clips.
Any objection? No, Your Honor. States 90 and 120 are admitted.
Permission to publish States 90.
You may.
All right, if you can pause it for just a minute. Can you orient us? Is this the McClay Commerce?
Yes, this is, the bus is pointing east. So just beyond that circle is where the flyover starts. If you're going southbound, you can take the flyover to get on Capitol Circle after you pass McClay Gardens and everything. So this car is on Thomasville Road, not the flyover, and it is going southbound.
All right, and this camera is mounted on the bus. That's how we were able to get this image?
Correct.
Okay.
This is a city bus.
Continue, please. And the time on this, 10:44 a.m., is
Correct.
that right? And what is this orange circle?
This is the Prius going the same direction as Markel's car, southbound on Thomasville Road.
Okay, now where are we?
This is southbound on Thomasville. We've gone underneath the I-10 overpass, and we're at Metropolitan Boulevard, and the bus just so happens to pull up right behind the Prius.
Based on the image in this exhibit right here, were you able to deduce the tag number of the Prius?
No.
That would have saved you a lot of
A
trouble,
lot
wouldn't it?
of time, yes. The video could not be enhanced anymore.
Does the evidence suggest that Markel had already gone on through past this traffic light?
Correct, because this car was behind Markel's car. So he must have beat the light or got through the intersection before this car.
Okay, now can you orient us?
I believe we're now at Thomasville Road, southbound at Benton. And that circle was the Prius in the left turn lane to go from Thomasville eastbound on Benton Road.
And is that the way to Mr. Markel's residence?
Not this time. He turned beforehand, we found out later on.
We found out later that Mr. Markel turned later on.
Yes,
But this is the
car
way the
turned.
suspect vehicle goes.
Right, he turns left.
Okay, can you get to Mr. Markel's residence from Benton Road?
Yes.
The way he turned?
Yes.
All right, now, can you back it up, please? So the last time we see the suspect vehicle turning off Thomasville onto Benton Road is what time? Hit play, please.
10:51.
Okay. And what time does our, pause it please, what time does our 911 call come in?
11:02 a.m.
Okay, so he was killed between 10:51 and 11:02.
Well, we narrowed it down even more than that. But,
Okay. Tell me how you narrowed it down further.
well,
than that.
this bus now, this is a different bus. Same city bus group, but this is a totally different bus. It's northbound on Thomasville Road. So based on the time, this bus is northbound, the shooting has already happened. And you'll see that the Prius catches up in the same lane as that black vehicle there next to the bus at 10:55, I believe. 10:55. Here it comes.
So that helps you narrow it down to what as the time of death?
10:50, well, at 10:51, he's in the Prius is in the turn lane. At 10:55, they've already left Prescott and they're northbound towards I-10.
Okay, and you say they. Why do you say they?
Well, here shortly, you'll see what appears to be two different individuals in the front seat of this car.
See something white moving around in the passenger seat?
Yeah, the white shirt, the person in that side of the car seems extremely animated, excited. And the other side, the best view that I've ever gotten is someone's in a black, solid black shirt or upper top.
All right, and this is a slowed down version to try to get a better look at those occupants. All right, what are these orange circles indicating?
These are characteristics of this car that we found to be unique. The passenger side mirror is solid black. These cars have, when they come new, the mirror is the same color as the car, the mirror casing on the outside. This one's been replaced, it appears, because it's black. The circle in the middle of the top of the windshield, that appears to be a sun pass or toll type pass activator. And then the lower bumper circle, that's where a tow hook can be threaded in for towing purposes, but otherwise it has a cap over it, and the cap is missing.
Were you able to deduce anything about the year of the Toyota Prius?
Based on the research that we did through Toyota, this was established to be a 2006 to 2009 Toyota Prius, and the color, as I said before, was silver pine mica.
All right, is it fair to characterize your investigation as having kind of two different veins at this point? We're looking at motive over here and we're looking at the Prius over here.
Correct.
Okay. And you mentioned the SunPass transponder, so we know this Prius, I'm assuming it's not the only silver pine mica Prius between 06 and 09 in the state.
Correct.
All right, so what do we do to try to track down the SunPass transponder?
I contacted Florida Department of Transportation, who administers the SunPass, and wanted to find out, what's the likelihood of that kind of car having a SunPass, and I was overwhelmed with, there was thousands. So that wasn't narrowing down anything very quick.
At that time, was SunPass more affiliated with South Florida, or did pretty much everybody in Tallahassee have one?
No, south and central, anything Orlando south for the most part.
Okay. Did you have any indication based on the surveillance video available as to where the vehicle went after it fled from Markel's residence?
I just know that right here it's going northbound towards I-10 from Thomasville.
All right. Let's watch to the end.
This intersection is Armistead, so this is north of Benton, heading back towards I-10.
Was any cell phone analysis worked on in this case?
Excuse me?
Cell phone analysis?
Yes.
Who performed the cell phone analysis?
Sergeant Corbett.
Okay, and is that something that was going on simultaneously as you doing this SunPass
That's correct.
thing? Okay. And did Corbett's work include trying to look for phones of interest traveling in the areas that we know where you found our suspect vehicle?
That and Premier Jim.
Okay. And we will talk to Sergeant Corbett later, but based on his analysis, did you have an idea or develop an idea of the route that your suspects may have taken?
Yes.
All right, and what did you do to follow up on that?
Well, initially, because of our large expanse of cars, we started looking for South Florida at any cars going through the interchange southbound at Wildwood, where you get on the turnpike from I-75. That was a bust. It was way too many. We couldn't find anything that was concrete. So once the phone analysis was done, we had a better idea that there was one particular number, and tracking that went southbound on I-75 all the way to Naples, and then crossing over on Alligator Alley, which is still I-75, from west to east, from Naples to Broward County.
And once you learned that it was actually this other route than what you would expect, were you able to do anything with in reference to the toll plazas and the SunPass transponder that you weren't able to do previously?
That's correct.
Okay, tell us about that.
Once we had that established, then I contacted the SunPass administrators again at Department of Transportation. And I explained to them what I had. I said, we got a Prius, a 2006 to 2009, Silver Pine Mica, not that they had that in the records. I says, but we have them going through approximately this toll plaza in Naples, going westbound. And once I gave them that and the time, within a couple minutes of when they would have gone through, they showed an activation with a transponder from the windshield at that toll plaza in Naples in Collier County, and there was only one Prius, and that's what we determined, that it was going back to South Florida and cutting across Alligator Alley.
All right, and were you able to backtrack and find the toll plaza record or SunPass record of the vehicle coming to Tallahassee as well?
Correct. On the 16th of July, that same transponder, we're talking about the sticker on the windshield, that same transponder went through from Broward County, West Broward County, through the other end of the toll plaza. There's one on each end. There's nothing in the middle. But one going eastbound, that same transponder on the 16th of July cut across Alligator Alley and then presumably went up 75, which the phone records will show that. And then the return trip was the first one we found.
And did that help you identify the particular SunPass transponder by like an identification number?
Yes.
And is a particular SunPass transponder affiliated with a particular vehicle through some type of SunPass record?
Yes, it shows the customer who purchased the SunPass, and they submit what kind of vehicle it is, the tag number, in case the the transponder doesn't work, they could still use their credit because it'll take a picture of the tag.
All right, so what did you learn about the suspect vehicle at this time from the SunPass stuff?
It was a rental. It was a rental from a Miami car rental place called Save Gas.
Okay. Did law enforcement go to Save Gas in Miami?
Yes.
Was there any documentation discovered at that business related to the rental of this vehicle?
There was.
67. I'm going to approach and show you what I marked as state 67. Recognize state 67?
Yes.
Okay, is that the rental contract that you found at the Save Gas related to your suspect vehicle?
That's correct.
All right. Is it a fair and accurate copy of that exhibit or that
Yes.
document? Okay, moving to evidence state 67, Your Honor.
Any objection? No, Your Honor. State 67 is admitted.
Permission to publish 67.
You may.
And what did we learn about the people that rented the car from this state 67? Not on there?
According to this document, Luis Rivera, Normandy Drive in Miami is the one that rented this car.
And did he provide a phone number for himself?
Yes,
Is that the number listed right here?
yes.
Okay. And any other drivers listed on the contract?
No driver listed there, but up in the top, you see the word brother and a phone number that became significant.
All right. And whose phone number were you able to associate? Who were you able to associate this phone number with? The brother.
Sigfredo Garcia.
When was this vehicle rented?
This on the 16th of July. I'm sorry, this shows 15th. 15th of July.
Okay. And when was it due back?
It was due back on the 17th of July.
Didn't go back on the 17th though.
No, I don't believe it got back till the 21st.
Okay. Approach and show you what I've marked in the States Exhibit 65. Recognize State 65?
I do.
How do you recognize it?
This was a traffic citation that we discovered Luis Rivera received on I-75.
On I-75 on the way to Tallahassee in the Prius?
No, it was a different car. This was on a different. This was dated June 4th.
I'm sorry, I've showed you the wrong thing. Not the right thing. We'll have to circle back to that. All right, let me ask you about phone. You mentioned that Sergeant Corbett was working on the phone records. I'm going to approach and show you what I marked as States Exhibit 55. You recognize this exhibit?
I do.
It's this sort of an org chart of all the folks whose phone records we collected in this case, or many of them.
Yes,
Okay.
that's correct.
And by stipulation, Judge, these phone numbers have been associated with the folks on the chart, so I'd ask to move into evidence States 55.
Defense is stipulated.
Yes, no objection to the publishing.
55 is admitted at this time.
Publishing States 55. Okay, well, we'll work on that too. Do that. All right. Now, Sigfredo Garcia and Luis Rivera, those are the two subjects that you establish as being in the Prius. Is that right?
Correct.
Okay. And these are their phone numbers that have been associated with them listed beneath them.
Correct.
And we've got two different numbers for Luis Rivera. Is that right?
Rivera had two separate numbers, but his main one was the 570 that was on the rental contract.
All right. And the The nicknames that are shown there, are those the nicknames that those two go by?
Correct. Tuto and Tato.
Tuto and Tato.
Correct.
Okay. Were you able to establish any link through people between the two that came in the Prius and the Adelson family?
No.
Okay. Were you able to establish any type, did you develop a theory or any evidence as to why these two people came to Tallahassee to murder Dan Markel?
Well, eventually we learned that the female, Catherine Magbanua, was the mother of Sigfredo Garcia's children and considered each other spouses, to my best understanding.
Okay, and
at
did
the
she
same
have...
time,
Go ahead.
same time, we also found out that she had been dating and in a relationship with Charlie Adelson.
All right, so initially, was there any connection between these two guys from Miami and Dan Markel?
None.
All right, so this was the connection that was established, turned out to be Catherine Magbanua.
The only connection we could find.
Okay, and was that done through phone records and ultimately other communication records and testimony?
That's correct.
Okay. Did you, as a result of developing Catherine Magbanua as a potential suspect, investigate her at all?
Yes.
All right, and did that include an investigation into her employment?
That's correct.
What was her employment status around the time of this murder?
At the time of the murder, I believe she worked at another dental office somewhere, but post-murder, she started receiving compensation from the Adelson Institute.
What is the Adelson Institute?
It's a dental practice, according to online information operated by Harvey Adelson and Charlie Adelson.
Okay, and were the two of them dentists?
Yes, I believe Charlie is recognized as a periodontist.
Did you come to learn what Donna Adelson's role, if any, was in that business?
Yes, she was clerical and kept books for the business.
Did you attempt to procure some employment records from the Adelson Institute to verify Ms. Magbanua's employment?
We did.
All right, tell us about that.
Myself and Special Agent Sanford from the FBI went to the office, physically to the office in Broward County, Tamarack, and served a subpoena seeking records for the employment of Catherine Magbanua, and we received nothing at the initial time. Later on, the best I could get from, I believe it was an attorney that represented that dental office, just a list of checks that were paid checks from the Adelson Institute to Catherine Magbanua, but no W-2, no responsibility forms, nothing that showed what she actually did as being employed at that institute.
What was it, regular business hours when you entered there physically?
Yes.
Was Ms. Magbanua present when you entered the building?
No.
Did the employees that you have contact with seem to know who she was or what it was that she did there?
The initial person that I spoke to at the desk, at the front desk, she had no idea who this person was, who Magbanua was. The other person that came up to the front, she said she knew the name, but did not know what her responsibilities were with the company.
And the person that knew the name, who is that?
Erica Johnson, I believe.
And I'm going to approach and show you 68. Recognize 68?
Yes, this is all I received as far as any type of records for Magbanua and her relationship with the Adelson Institute.
All right. And did the records include any job description for Ms. Magbanua?
No,
Any employment application?
no,
Schedule?
no,
Timesheet?
nope,
W-2 forms or tax filing records?
nope,
Any performance evaluations?
none.
So only the checks.
Only the checks.
According to those checks, during what period of time was Catherine Magbanua on the Adelson Institute payroll?
From September of 2014 all the way, this particular one shows March of 2016, but I believe it goes further than that into May 2016.
All right. So it starts shortly after the homicide, about 2 months?
Yes. Actually, the homicide happened July 18th, and the first check was dated September 18th.
For what pay period?
I don't see the pay period on this one.
But presumably she'd be paid for a pay period that had
2 weeks
concluded.
prior. According to the way this is laid out.
All right, and we are going to learn more about the bump or the undercover operation, but is it fair to say the checks terminated shortly after the undercover operation in 2016?
Yes.
Did you notice in your review of that exhibit, the documents provided by the Adelson Institute, that some of those check numbers were consecutive?
Yes, I did.
Who signed those checks?
Donna Adelson,
All of them?
everyone.
Were you ever able to develop any evidence that Magbanua was physically going to the Adelson Institute during these pay periods?
Never.
Any evidence that she performed some service off-site for that business?
Nothing was established that showed that.
Any evidence of any contact with any patients?
No,
And you were, we'll learn later, listening to some of her phone calls, right?
that's correct.
When was Catherine Magbanua arrested for her role in this murder?
October 1, 2016,
Were you present for her arrest?
I was.
And was she allowed to contact her lawyer from the arrest scene?
Yes,
Did you speak to her attorney as well?
I did.
Who was her attorney?
Tara Kawas.
What happened after that phone call?
After Ms. Magbanua was placed into a car for transport to the Broward County Jail, way less than 20 minutes later, I received a phone call on my phone.
Because lack of relevance, not to testify to something that has nothing to do with my client.
You obviously need objections. Ms. Cattleman, please lay the foundation as to this matter in this trial.
Co-Conspirator statement, Your Honor.
Overruled.
Go ahead, sir.
So, so let me back up. So, while Ms. Magbanua was detained on scene, where she was arrested in the daytime, daylight hours, she was allowed to place a call to her attorney. She spoke to her attorney. I spoke to her attorney, and I asked that Ms. Kawas, the attorney representing her at the time, that she contact her client, Magbanua, at the Broward County Jail, and if in fact she wanted to cooperate with the investigation, to call me back
So you were
And-
interested in getting information from Ms. Magbanowa?
Correct. I wanted-
Information about the other parties involved in this case?
Yes.
Okay.
So what I mean by cooperation is if she wanted to provide testimony about other players in this. And so I told Ms. Kwas, you know, if you'll talk to your client, obviously out of my presence, and if she decides to cooperate, call me back, and I will go to the Broward County Jail and meet.
Did that happen?
No.
What happened instead?
Well, like I said, within less than 20 minutes from that conversation, I received a phone call from a gentleman that identified himself as David Marcus. Instead, he was an attorney representing Charlie Adelson. And he asked that if Charlie Adelson was to be arrested, if I would just contact him.
Your Honor, when I reviewed the objection, there's relevance, and this is not co-conspirator admission.
Specifically as a co-conspirator aspect, Ms. Kappelman, you need to keep the examination focused on that. Members of the jury, as to the last objection, I will sustain it. You may continue, Ms. Kappelman.
So you speak to Kwas, and your next phone call is from Charlie's lawyer.
Correct.
No further questions.
Cross-examination.
Just a moment, Your Honor. Good afternoon.
Good afternoon.
Okay, so at the time of this investigation, when it began, how long had you been with the Tallahassee Police Department?
25 years.
You'd spent vast majority of your career as an investigator detective.
No, I've probably spent most of my career as a street officer.
Okay. At the time of this, how long had you been a detective?
6 years.
And you continued to be the lead for Tallahassee Police Department on this investigation until your retirement, correct?
Correct.
Now, it's important when you're conducting an investigation, especially a homicide investigation, for you to be thorough, correct?
Yes.
You don't want to leave essentially any stone unturned,
Yes.
obviously within reason.
Yes.
You talked about your agency beginning to obtain cellular phone records of the Adelson family pretty early on, correct?
Mm,
You started getting them in July?
yes.
Okay. And you learned that Wendy Adelson's parents, my client and her husband, lived in Miami, correct?
I believe at the time it was Coral Springs, but,
They had a place on Miami Beach?
well, I know that they ended up at Miami Beach. I don't recall at the time of the homicide if they were living on Miami Beach.
Okay. But you knew that they were in South Florida?
South Florida is correct.
Okay. And so as your investigation continued and you started looking into, you made the connection between the two individuals who drove up here, Sigfredo Garcia and Luis Rivera. You made that connection to Catherine Magbanowa, correct?
Right.
And you made that connection to Charlie Adelson, correct?
Correct.
And then you see these large cash deposits into Katie Magbanowa, or you see Katie Magbanowa's unemployment status.
Right.
She's still paying her bills in South Florida.
Yes.
Okay. Now, you also mentioned that you contacted the SunPass Authority.
Yes.
Okay. Did you ever, you'd already made a connection between the investigation and the Adelson family at this point, pretty quickly.
I wouldn't say that.
Okay, well, over a couple years. By the time June of 2016 comes, comes about, you've already made that connection.
Oh, yes, by that time, yes.
Okay. And you contacted the SunPass Authority for my client's SunPass records, correct?
No.
No, you didn't. Did you contact the Turnpike Authority for construction records for the Turnpike?
Construction records?
Yes.
No.
What about for I-95 or 595?
To my knowledge, there is no, and I believe I established that with the FDOT, Florida Department of Transportation, that there was no toll system on 95.
Okay. I was asked about construction records on 95.
I did not inquire about construction records.
What about accident records?
Accident records?
Yeah.
No.
Isn't it true that my client and her husband shared an email address?
I believe they did.
You learned that during your investigation. In fact, I think Wendy said that, didn't she? In her interview with you?
I don't recall whether she said it.
Where is... Do you have 64 up here still? Mr. Isom, you identified emails that are contained in State's Exhibit 64, correct?
Yes.
And according to your testimony, these are emails between my client and her daughter, correct?
Yes.
Let's see. And in some of these emails, my client called Danny Markel bad names.
Yes.
She never actually said she hated him, did she, in any of these emails?
That came through the grandchildren.
Okay. At the time, the grandchildren were 3 and 4.
I don't recall the age. They were young.
And you also testified about a bribe. You are not a family law attorney, are you?
No.
Okay. And you have no idea whether or not it's permitted for one party to offer any sort of financial incentive to another party when it comes to relocation.
That's not in my realm.
And you also testified about Mr. Markel's life insurance policy, pension, and you said that those funds went to his children with Wendy as a custodian?
Some of them, and some of them was Dan Markel's sister as the custodian.
Okay. Did my client receive any financial benefit in the form of Danny's life insurance, his pension, or anything else?
Not that I could tell.
Going back to those emails, especially the one the state highlighted concerning the Catholic Church and dressing the kids up, Wendy didn't take those suggestions, did she?
No.
You testified just now concerning your attempt to obtain employment records for Miss Magbanua from the Adelson Institute. It's a small business, right?
It appeared to be.
Just a handful of employees?
Yeah, there was only 2 there at the time.
You don't know whether or not any of the employees had a written job description?
No, I do not know that.
You don't know if any of the employees' files had evaluations or job reviews?
I didn't see that. I would think with that type of business and working on people's mouths and so forth that there would be a little scrutiny involved.
But you don't know if they kept those records for any employee,
I have no
do
idea.
you?
I was only seeking and only had cause to seek for Magbanua.
And when Ms. Magbanoa was arrested, you testified that you received a call from someone who identified himself as Charlie's attorney, correct?
After her arrest, the gentleman that called my number was he identified himself as an attorney for Charlie Adelson.
Not Donna Adelson.
Not Donna.
Now, is it unusual in an investigation like this for a defense attorney to contact you about whether or not there's a warrant for their client's arrest?
I wouldn't say that. If I can. It was shocking to me that within that short a time frame, the only way that this person would have knowledge would be from Magbanoa's attorney. So there would be contact between Magbanoa's attorney and this person identifying himself as Charlie's attorney in a short, very short time. No media, nothing had been divulged.
So what you found unusual was the short time frame, not the phone call itself.
No, it was immediate, and I'm basically telling Coas, if your client wants to cooperate, contact me. Don't call somebody else that's a co-conspirator, their attorney.
You didn't receive a call from anyone identifying themselves as Donna's attorney in that instant, did you?
No, sir.
Okay. Ms. Kappelman asked you about what has been coined that grandmother motion. Again, you're not a family law attorney.
Right, still not.
And so although you read the motion,
Yes.
and you're educated, absent having some legal knowledge, can you interpret what is being requested in the motion?
I believe so. I think it's pretty plain.
Okay. I'm glad you said that. Now, I want to go back to the emails, and I'm going to use the board. The emails that you testified were between my client and her mother.
I just if we needed to take a break.
I'm going to show you 64EE. Let's see. The sender of this email is not Donna Adelson, is it?
No, it doesn't. I don't know who it's from. It's not showing it.
Okay, it's an evite.com invitation.
I've seen those.
Okay. You don't have any personal knowledge as to how these are generated, do you?
Someone has to go through this program to get it set up and sent out.
But you don't have any personal knowledge as to how that's done, do you?
No.
The next page of EE, it's a August 30th, 2014 email to Wendy. Now, the sender is donnaharvey@gmail.com, correct?
That's correct.
Whose name is next to that?
Harvey Adelson.
That's not Donna Adelson, is it?
No, I believe that's her husband.
Next. It's an email dated September 12th, 2014 And the sender is saying that Lincoln will attend Tot Shabbat with his grandpa, Harvey Adelson. Isn't that what it says?
Yes, it does.
Who's it from?
It's from donnaharvey@gmail.com.
And whose name is next to that?
It says Harvey Adelson.
I'm going to show you 64FF. This is, again, from Harvey, donnaharvey@gmail.com, correct?
Yes.
Okay. Whose name is it there?
Where it says from,
Yes.
it says Harvey Adelson.
Okay. Wendy, this is the information on work order for repair of TV, Friday, July 18th, between 8 and 12. Love, Dad. My
Yes.
client's not Dad, is she?
I wouldn't refer to him as that. I don't think she would either.
Now, this is still part of that same email, the Geek Squad schedule. Would you be willing to accept a sooner appointment if one become available? Do you see that language?
Yes.
What's the answer underneath that?
Yes.
Nothing further, Your Honor.
Redirect examination. Go ahead.
Defense pointed out, hey, Harvey and Donna share an email address, right? DonnaHarvey@gmail.com. And some of these are signed Dad.
Right.
Are some of them signed Mom?
Right.
Okay, and drawing your attention to this one on May 3rd, 2013, including the statement, the most important part of your divorce is relocation. On page 4 of that exhibit, well, let me start by going to the very end. Inconveniently, the way this printed, love you. Who signed that one?
Mom.
All right, and on page 4 of the exhibit, just a moment. State's Exhibit W, this is one from Thursday, June 27th, 2013. It's signed Mom and Dad, right?
That's correct.
Okay. And in this one, so we've got some from mom and dad, right?
That's correct.
No further questions.
You may step down, Mr. Isom. Will he be retained? You may be recalled at some point in the trial. Please remain in contact with the attorneys. What's that?
Am I under the rule?
Yes, sir.
Thank you, Judge.
You're welcome. Members of the jury will take a break at this point briefly. The bailiff will take you to the jury room. Everyone can be seated. Just a reminder for the gallery, while the testimony is taking place, if you step outside of the courtroom, you will need to wait until the examination of that witness is complete. We will resume at 3:50.
May I address the court while she's working on the
Go
jury?
ahead.
I would like some clarification on the hearing that is going to be conducted outside the presence of the jury regarding State's Exhibit 60. My takeaway from our sidebar was that I was going to authenticate every single page. The defense has now advised me they only have limited objections to State 60, so I would ask for some clarification on what we're doing there.
Starting 60, the defense can be heard.
I think we resolved that with the court's ruling already, Your Honor.
I believe the captain just brought it up because there might have been a discussion while I was in the room.
I think
No.
Ms. Fulford thought that she was referring to some of the...
I thought you were referring to the email.
Oh, no, I'm
For
referring to the
64,
divorce.
State Exhibit 64 has been admitted with the only exception being AA for right now.
Right, that was my bad. I thought that's what she was referring to when I said
Okay.
hers.
As to State 60, the foundation has begun with the detective as to any other witnesses that you intend to link up the parts of the foundation with. You are certainly permitted to do so.
Is there an objection to it right now being admitted?
I
And
believe
if
the objection
so-
was foundation as to showing emails or communications that link up exactly with what the pleadings are.
Yes, sir. And will that be in reference to each pleading or just select pleadings?
Mr. Zelman and Ms. Fulford.
Judge, my understanding from the court's ruling is that the state could lay the foundation as they move through their case. And with that ruling, I mean, obviously we'd like them to establish foundation, but I'm not objecting to what has been presented as 60 other than the foundation, which, as you indicated, they can prove up along the way as long as they complete it by the end of their case in chief.
Well, until the foundation is complete as to State 60, it is not admitted.
Understood. Okay, I am going to go forward with Mr. Rivera at this time, Judge. If we finish before 5, I'm hopeful that I'll be able, outside the presence of the jury, to conduct that hearing regarding the foundation and admissibility of that exhibit. Would that be acceptable to the court?
That's fine.
Okay. I'm not sure I'm going to be ready. I'm working on that, but just wanted to have clarification on what I was working on.
Please bring in the jurors.
And can we have Mr. Rivera brought in?
You want it brought in now before?
Want to have him seated before we bring
You,
in the
you
jury?
can bring in Rivera first. You can bring in the jurors. You can take a seat for right now, Mr. Rivera.
So you're closer to that microphone.
All rise, you're entering the courtroom.
Everyone can be seated. Mr. Rivera, please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
Take your seat. Please speak loudly and clearly.
Yes, sir.
You may examine.
Sir, please introduce yourself and spell your name.
Luis Rivera, Luisrivera.
Mr. Rivera, where are you from?
I'm from Puerto Rico.
Okay, but were you living in Miami back in 2014?
Yes, ma'am.
How long did you live in Miami?
My whole life.
You were born in Puerto Rico, though?
Yeah.
Okay, but moved to Miami at what age?
2 years old.
Okay. Have you been convicted of a felony?
Yes, ma'am.
Including the murder that we're here about today?
Yes, ma'am.
It's 5 felonies, sound correct?
Yes, ma'am.
And you're currently incarcerated?
Yes, ma'am.
Is that for this case or this case and another case?
Both. Well,
Both. So it's a federal sentence and this sentence.
State case.
What did you plead to in this case?
This case, guilty
Guilty to what?
to second-degree murder.
If you can speak up, Mr. Rivera, that'd be so.
Guilty to second-degree murder.
Thank you.
One moment, Mr. Rivera.
What was your sentence on the second-degree murder?
19 years.
Okay, and that was concurrent with your federal sentence, right?
Yes, ma'am.
Okay, and what did you have to do in exchange for getting a 19-year sentence?
I had to cooperate.
What does cooperation mean to you?
Well, telling.
Telling on who?
My co-defenders, Garcia, Katie.
All right, did anybody ever tell you what to say?
No, ma'am.
Has anybody ever told you anything other than to tell the truth?
No, excuse me? Say it again?
Has anybody told you to say anything other than the truth?
No.
Has anybody promised you anything other than the sentence that you got in exchange for cooperation?
No, ma'am.
Did anybody ever tell you, oh, you have to testify about a specific person to get a deal?
No, ma'am. Not at all.
Have you been offered anything on your federal sentence from doing this cooperation on this case?
No.
As part of your negotiation or your lawyer's negotiation of this case, did you give up what's called a proffer, a recorded proffer?
Yes, ma'am.
All right. And even back then when you gave the proffer, did anybody tell you what you needed to say there?
No, ma'am.
Were you hired to participate in the murder of Dan Markel?
Yes, ma'am.
Who hired you to be involved in the murder?
Well, I got it from my friend, Dudo Garcia.
Is that Sigfredo Garcia?
Yes, ma'am.
How did you know him?
Childhood friends.
So to cooperate and get this deal, you had to turn on one of your best friends.
Yes, ma'am.
Who enlisted Sigfredo Garcia to be a part of this murder?
Katie,
Who's Katie?
his wife.
Is that Catherine Magbanoa?
Yes, ma'am.
Do you know who enlisted her to be involved in this murder?
Not really.
Was it a murder for hire?
Yes, ma'am.
Did you know that somebody was paying Katie?
Yes, ma'am.
And Katie was the one that brought the money to you all, right?
Yes, ma'am.
And what was the purpose of this murder as you understood it?
That they wanted the kids.
Who wanted the kids?
Wendy.
Okay. And did you understand that you were killing the father of the kids so that Wendy could have the kids?
Yes, ma'am.
Have you previously referred to a dentist being involved?
Yes, ma'am.
Who was the dentist?
Charlie.
And how was he related?
Katie's boyfriend, side piece, whatever you want to call him.
All right, so Katie was the wife of Garcia, but also the girlfriend of the dentist?
Yeah.
Did you have any contact with the dentist ever?
No.
Did you have any contact with any member of the Adelson family?
No, ma'am.
Everything went through Katie, right?
Yes, ma'am.
What did the dentist, if you know, have to do with the lady in Tallahassee who needed her kids?
I don't know nothing about him. I don't know nothing about that family.
Who was in charge of getting the money after the job was done?
Katie.
How much were you to be paid for your part in this crime?
35.
$35,000?
Yes, ma'am.
Did you know the total amount that the job paid?
No, not really.
Did you know how much Garcia got?
40, I believe.
$40,000?
Yeah.
And did you know how much Katie got?
No, I don't know. Can't remember. But I think it was like 40. I think it was total was be like 100, something like that.
Okay, somewhere in the neighborhood of $100,000.
Yes, ma'am.
Was it a one-time payment or was it a payment that occurred over time? Is what you got?
No, it's a one-time payment.
What did you know about the man that you came to Tallahassee to kill?
I don't know nothing about him.
How did you know who to kill?
Prosecutors. Garcia.
How did he know?
Katie.
Did he have some information about the man you were here to kill?
Yes, ma'am.
Tell him what that was.
I was a piece of paper with his picture on of his face and the address.
Picture of Dan Markel's face?
Yes, ma'am.
And the address of what? Where he lived?
Of his house, yes.
Did you and Rivera refer to each other, I'm sorry, you and Garcia refer to each other as brothers?
Yes, ma'am.
Moving to evidence states 45, Your Honor.
Objection.
No, Your Honor.
States 45 is admitted.
Is that you and Mr. Garcia?
Yes, ma'am.
Please silence your phones.
Have you ever been to Tallahassee before you came for this case, related to this case?
Never in my life.
How many times did you come to Tallahassee related to this case?
This case twice.
All right, so were you with Sigfredo Garcia both times?
Yeah,
Was that one time in June and one time in July?
I believe so.
Okay, and July was the time, second time was when the murder happened, is that right?
Yes, ma'am.
Was it just the two of you on both of these trips?
Yes, ma'am.
The objection states 44. No objection. Introduce states 44, Your Honor.
States 44 is admitted.
Publishing states 44. Who's this right here?
Garcia.
And this?
Katie.
Who's that?
My baby mama.
Your child's mother?
Yes, ma'am.
What's her name?
Jessica.
Okay, and that's you there?
Yes.
Was this picture taken before or after the murder?
I can't remember.
At the time of the murder, was Katie with the dentist? Was Katie with Garcia? Was she with both?
Both.
Were you at the time of this murder living with Jessica Rodriguez?
Yes, ma'am.
There's an address on the rental car contract, 1515 Northeast 135th Street, number 14. Do you recognize that address?
That's my apartment. Yes, ma'am.
Okay. All right, let's talk about the first trip that occurred in June. How did you get here for that trip?
Well, we rented a car.
Who rented the car for the June trip?
The first one.
Yeah, if you remember.
I can't really remember. Been so
Okay.
long.
But one of you, either you or Sigfredo?
Yeah, I think it was Fredo. I rented the Prius, so I never rented on the car.
Okay. So Garcia rented the car for the June trip, but it was a rental car that y'all brought up here.
Yes, ma'am.
Okay, and did you take the same route on both trips to get to Tallahassee?
Shit, I don't remember.
Okay, and did he have the paper with the picture of Dan Markel on both trips?
Yes.
And what did you do on the first trip?
We drove by here and we just followed him around to see where he lived and shit. But
Okay, were you planning to kill him on the first trip?
I don't remember.
Okay, did you have a gun on the first trip?
Yeah.
Did you have a gun that you procured specifically to kill Dan Markel with?
Yes, ma'am.
And was that a gun that you bought off the street?
Yes, ma'am.
You bought it?
I bought it.
Okay. And were there any other guns in the vehicle for that first trip, if you know?
I think we had 2.
All right, and what was the other gun?
It's a 38.
Whose gun was that?
Garcia.
On that first trip in June of 2014, did you and Garcia go to Markel's residence?
Yeah.
And did you lay eyes on him that first trip?
I believe I passed by his house and scoped him out.
You said you followed him. Do you remember where you followed him on the first trip?
Yeah, I followed him to a daycare.
Okay. How long were you here that first trip?
Maybe I don't remember.
A couple days sound right?
Just a couple of days.
Why wasn't Dan Markel killed on that first trip, if you know?
If I remember, I wasn't gonna do nothing in front of no kids. But
He had the kids with him,
yeah, yes, he did.
but for whatever reason, it didn't happen on that trip.
We lost him. I believe we lost him.
Okay. And when you didn't get it done on that trip, was anyone angry at you?
At me?
Yeah.
I don't think so.
All right. Did you hear at some point that y'all were going to have to come back if you wanted to get the money and finish the job?
Yeah.
All right. So you did come back in July. Is that right?
We came back.
And that's when you came in the Prius.
Yes, ma'am.
And you rented the Prius, right?
Yes, ma'am, I did.
Okay. And that phone number that you wrote on the Prius rental agreement and wrote brother, that was Garcia's phone number?
Yeah, I think.
You took phones with you to Tallahassee for both trips, right?
Yeah.
Did you turn your phone off for the actual murder?
Yeah, I did.
What about Garcia? Do you know if he turned his phone off?
When the murder happened?
Yes, sir.
Shit. Man, I don't remember.
Okay. Did you stay in Tallahassee for a couple nights when you came here the second time?
Yeah, we stayed here for a night or 2, I think.
Okay. Did y'all rent a hotel room?
Yes.
Do you know how many guns were with you on that second trip?
Nah, just 1.
You only remember one gun on that trip?
Yeah, I remember 1.
And that's the murder weapon?
Yes, ma'am.
The one you bought on the street?
Yes, ma'am.
What type of gun was that?
A 38?
That's a revolver?
Yes, ma'am.
Do you remember an incident where there was a shot fired into the floorboard of the Prius?
Yes.
Could you tell the jurors about that?
Well, we was driving and Garcia put the gun out and shot the gas line in the car.
Through the floorboard of the car?
Yes, ma'am.
Passenger side or driver's side?
Passenger side.
Okay, and that was the murder weapon that fired that shot?
Shit. Man, I don't remember.
Okay, but he was messing around with some gun and fired it into the car.
Yeah.
And were y'all driving in the car when that happened?
Yes, ma'am.
And did it disable the car?
The car started stopping. Little by little, it just started slowing down.
Okay, that's the Prius, right?
Yes, ma'am.
How did y'all get the car going again?
We seen somebody that he knew and stopped him and took him to the auto place to get a piece of hose to put it back together.
And the guy that you saw that he knew, are you talking about a local drug dealer here that y'all had met on the first trip?
Yes, ma'am.
And that person assisted you in getting some way to fix the car?
Yes, ma'am.
Who was good with cars, you or Garcia or both?
Garcia.
All right, so he was able to make a repair to the gas line?
Yes, ma'am.
Did you follow Dan Markel again during this second trip?
Yeah.
Did you follow him to the daycare?
Yes, ma'am.
Did you actually see him drop his children off at school that morning?
Absolutely, yes.
Did you follow him to the gym where he went inside and worked out?
Yes, ma'am.
Was there a reason the murder had to be done on the day that it was done?
I believe so. I believe he was about to leave.
Who was about to leave?
Markel.
About to
Markel.
leave town?
Yeah.
How did you get that information?
I got it from Tudo,
Where did he get the information?
from Katie,
How did she know?
Wendy.
You think Wendy talked to Katie and told her Dan Markel's travel plans?
Yeah.
Were you present for that
No.
phone call? Okay. But somehow you learned that Dan Markel was leaving town the day after he was killed.
Yes, ma'am.
So it had to be done that day or he'd be gone.
Yes, ma'am.
Okay. And that came through Garcia to you from Katie.
Yes, ma'am.
And when you say Wendy, did you know who Wendy was at the time that all this happened?
No, ma'am.
Okay, but you did know there was a lady that you were helping get some kids back in Tallahassee?
Yes, ma'am.
Okay. Were you the driver of the green Prius?
Yes, ma'am.
Have you had a chance to see the gym video and the bus video?
Yes, ma'am.
Are you driving the Prius in those videos?
Yes, ma'am.
What happened when you got to the driveway of Dan Markel?
Well, I pulled up right behind him, and Garcia jumped out and shot him.
How many times did Garcia shoot Mr. Markel?
Twice.
Did he shoot him? Where was the victim when he was shot?
He was inside his parking garage, and his sitting down on the driver's side on the phone
And did Garcia shoot him through the window, if you know?
through the window.
How long would you say you were in the driveway?
Just seconds.
How was it decided which one of you would be the shooter?
Because I wasn't gonna do it.
You didn't want to be the shooter?
No.
On the bus video, we see somebody in a white shirt kind of jumping around in the passenger seat. Is that Mr. Garcia?
Yes, ma'am.
Do you remember what was happening when he was doing all that jumping around?
I think he was trying to hide a gun. If I'm not mistaken, he was trying to hide it.
What did happen to the gun?
It got thrown away
Thrown away where?
in the ocean somewhere.
All right, who threw it in the ocean somewhere?
He did.
All right, was that on the way back to Miami?
Yes, ma'am.
At some overpass somewhere between here and Miami?
Absolutely.
Where did you go after the murder? Did you go home?
We had to stop somewhere to eat. Then we went home.
Did you stop at an ATM?
I don't remember.
I'm going to show you states exhibits 38, 39, 40, 41, 42, and 43. So 38 through 43.
Yes, ma'am.
Are these images fair and accurate photos of you pulling through an ATM?
Yes, ma'am.
And the date, July 18th, 2014?
Yes, ma'am.
Pembroke Pines, is that on the way home from Tallahassee?
Yeah.
And that's you at the ATM, are you the driver?
Yes, ma'am.
And who's that in the passenger seat?
Garcia.
Move to publish introduce states 38 through 43.
Any objection?
No objection.
States 38 through 43 are admitted.
May I publish?
You may.
Is that the vehicle you were driving the day the murder was done, sir?
Yes, ma'am.
Publishing 39. Is that you at the ATM machine?
Yes, ma'am.
States Exhibit 40. Is this Mr. Garcia? Is he your passenger?
Yes, ma'am.
States Exhibit 41. He's the passenger that was jumping around when we saw the car in Tallahassee on the bus video?
Absolutely.
Do you remember when you turned your phone back on after the murder?
Not really.
Do you remember who was the first phone call that either of you made after the murder?
Garcia.
Who did Garcia call?
Katie.
And were you able to hear Katie on the other end of the line when he was talking to her?
Yes, ma'am.
And were you interested in that phone call?
Yes, ma'am.
Because she was going to be the one to get you the money, right?
Absolutely.
And was that phone call in reference to letting her know it's done and she's going to get the money?
Yes, ma'am.
When did you get the money?
Saturday morning.
Was that the next day?
The next day.
Do you remember that on that Saturday morning you got a call from Catherine Magvanoa?
Yes.
She was looking for you to give you the money, right?
Yes, ma'am.
And was that unusual for her to call you?
Not really. She never calls my phone.
She never calls your phone, but she couldn't get a hold of Garcia,
She
right?
couldn't get a hold of him, so she got in contact with me.
Okay. And at that time, wasn't Garcia living with another woman?
Yes.
And that was the woman that goes by the nickname Shrimp?
Yes, ma'am.
Okay, and that's where you ended up rousting him out of, right?
Absolutely.
To go get your money, right?
Yes, ma'am.
Okay, so he wasn't living with Katie as a family at that time.
Nope.
Okay. So when you say that Katie was with both of them, do you mean just that Katie was always kind of off and on with Garcia?
Yes, ma'am.
So she has other boyfriends, sometimes he has other girlfriends, but they always find each other again?
Absolutely.
One moment, please, Your Honor. All right, tell us what happened when you got your money. How'd you get it? Where'd you get it?
Oh, I was in a barbershop, and they pulled up to my house, Katie and Garcia, and they called my phone. Hey, I think my baby mama called me. I think my baby mama called me. Well, they came to my house.
Okay, Katie and Garcia brought the money.
Yeah, I was in a barbershop, and
Okay.
Katie and Garcia, they went to my house and brought the money.
All right, and do you know where Katie got the money from? Were you there when Katie got the money?
No.
But you knew that she was supposed to go get it,
Absolutely.
and she did.
Yes, ma'am.
How much did you get?
35.
Was there anything unusual about how your payment was packaged?
Yeah, it was weird. It was stapled. Never
Was it
seen that
cash
before.
money?
Cash.
Okay, stapled how? All hundreds.
All hundreds, $1,000 stapled.
Stapled into bundles of $1,000 each.
Yes, ma'am.
Have you ever seen stapled money before?
No.
Did you and Garcia buy anything with your cut of the money?
I just bought a motorcycle.
Any objection 46 and 47? No objection. Moving to evidence 46 and 47, Your Honor.
No objection to the defense.
No objection.
They are admitted.
Publishing States Exhibit 46. This yellow motorcycle, whose is that?
Garcia.
Is that something he bought with the money that was the proceeds of this murder?
Yes, ma'am.
Okay, and what about this vehicle back here?
Yeah, he bought that one too.
He also bought that with his cut of the money?
Yeah.
And States Exhibit 47, what about this motorcycle right here?
That's mine.
Is that what you bought, or part of what you bought with your money?
Yes, ma'am.
How long after the murder did you guys make those purchases? Days, weeks, months?
Probably like a month.
Did you make any changes to your cell phone after the murder? Did you dump your cell phone?
I don't remember.
Did you meet with Investigator Newland from my office to see if you could recognize some voices on some recorded telephone calls?
Yes, ma'am.
And did Mr. Newland play some calls for you and have you initial on a sheet if you could identify the voice on the
Absolutely.
sheet on that call.
Yes, ma'am.
Right. State's Exhibit 136, please, is it? I'm going to show you what I have marked as State's Exhibit 136. Yes. Do you recognize this exhibit?
Yes, ma'am.
And are these your initials here?
Yes, ma'am.
And does that mean you're verifying that the highlighted name, you know that person and that is their voice
Absolutely.
on the particular call that reference?
Yes.
Judge, at this time, I'd ask to move into evidence 136.
Objection. State's 136 is admitted.
One moment, please, Your Honor.
Take your time.
Did you know where the dentist lived?
Nope.
Did you know that the dentist had a safe full of money?
Nope.
Did you know that the dentist was going to be paying for at least part of this murder?
No.
And if you had known that the dentist had a safe full of money, would you have driven all the way to Tallahassee to do the murder to then get the money?
No.
What would have been a better idea?
Overruled, he has knowledge of his own actions and what he was thinking at the time.
What-
Answer the question.
What would you have preferred to do to get the money?
I would have went and robbed them myself.
Did you suggest to Garcia on the way up to Tallahassee that y'all could just go to whoever had the money and rob them instead of doing this murder?
I mentioned something like that, yes.
But that, Garcia said that wouldn't work, right?
No.
Nothing further.
Cross-examination.
Good afternoon, Mr. Garcia.
Excuse me?
I said, good afternoon.
Good afternoon.
I just want to make sure I understood your testimony. It was your testimony that the first trip you came up on, you scoped out Mr. Markel's house, correct?
Yes, ma'am.
And that he was going to be taking his kids to school, so when he came out with the kids, you're trying to follow him to the school, correct?
Yes, ma'am.
And you got lost. He lost you.
Yes, ma'am.
Okay. And the second time that you came up, you knew he was going to be taking the children to school, and so you followed him to the school, correct?
The daycare, yes.
Yes. And then you knew he was going to be going to the gym, right?
I didn't know he was going to the gym. I just followed him.
You followed him to the gym.
Yeah.
Okay. And then you followed him to his house.
Yes, ma'am.
And that's where he was killed.
Yes, ma'am.
And the woman who wanted him to be killed, past you and Sigfredo and Katie, the woman who wanted him to be killed was Wendy Adelson, correct?
Yes, ma'am.
It was she wanting her children, correct?
Absolutely.
May I approach, Your Honor? Mr. Garcia, I'm going to show you what has
Mr.
been...
Rivera.
Oh,
not
I'm so
Garcia.
sorry. I am so
Twice.
sorry. I apologize. Mr. Rivera, I'm going to show you what's been marked as Defendant's Exhibit 50. Could you take a look at that and tell me if you recognize that?
Yeah.
And what is that?
Like a profile of everybody's face.
Okay. And did you make some marks on this for me and then sign it on March the 11th of 2025?
Yes, I did.
You just hold on to that for a second. Mr. Vera, when we met with you that day taking your deposition and I presented that to you, you gave us information about what had happened, pretty similar to what you talked about here today, correct?
Yes, ma'am.
And when we were done talking about those things and some information about Sigfredo and Katie, I presented you with what's in front of you as Defendant's Exhibit 50, correct?
Yes, ma'am.
And I asked if you would put the number 1 and circle it next to the person you know as Katie, who you said was in charge of this whole deal, correct?
Yep.
And did you do that?
Yep.
All right. And then I said, would you put a number 2 next to the person you say did this killing?
Yes.
And you did that, correct?
Yes, I did.
And that was Sigfredo Garcia.
Yes, ma'am.
The first one was Katie McBanois, correct?
Yes, ma'am.
And then I said, would you put a number 3 next to yourself on the paper? And did you do that?
Yes, ma'am.
And you're the one who got the gun that was used to kill Danny Markel, and you drove the car that day. You didn't shoot him, right?
Yes, ma'am.
Okay. And then I said, if you would, please put the number 4 next to the man who was killed, and you did that with Danny Markel, correct?
Yes, ma'am.
And then I said, if you would, put the number 5 next to the lady that wanted the man killed. And did you do that?
Yes, I did.
And was that with Wendy Adelson?
Yes, I did.
And then I asked you if the 2 people on the top of the page who have their pictures there and the names Donna Adelson and Harvey Adelson, you see those on the top?
Yes, ma'am.
I asked you, as far as you know, were they involved in any of this? And you said no, correct?
Yes, ma'am.
So I asked you to put X's next to the people who on that page were not involved in this.
Yes, ma'am.
And you did that.
Yes, I did.
Thank you. Just one moment, Your Honor.
Take your time.
I don't have anything further.
Redirect examination.
No, Your Honor.
Is Mr. Rivera released or will he be recalled?
He's to remain under the rule, Your Honor.
Very well. Mr. Rivera, please do not discuss your testimony with anyone else. The bailiff will take you at this time. Parties can approach. Jury, at this time, we are going to go into recess for the day. The same instruction that you have received since the start of jury selection, not to discuss the case with anyone else or to look at any information about the case. Once again, I'm going to remind you of this. Please report on Monday morning at 8:45. We will anticipate getting started by 9 o'clock. Enjoy your weekend. We will see you Monday.
Judge, before they step out, may we touch on one other item?
Yes. Members of the jury, actually, please report at 9:15, and by the time everyone has reported, we'll expect to get going with the trial by 9:30. Have a good weekend. Once again, do not discuss the case, do not read or seek out any information about the case. Have a good night. Ms. Kappelman, the witness is here this afternoon to start that, or you need to do that on Monday morning?
I can start that this afternoon, Judge. We're just not prepared to go through the whole thing yet. We've been working on it since the issue arose. And I was told we're about halfway through, about 10 minutes ago, so.
All right. If we can start at 8:30, have the witness and go through it smoothly, it'll give everyone an opportunity to get some rest for the weekend. Do you all prefer to do it that way?
Thank you, Judge.
Yes, sir. Thank you.
Judge, I did fail to introduce one of the ATM still images, Exhibit 37. Would it be acceptable to move to admit this?
If you're relying on the same foundation provided by Mr. Rivera, unless there's an objection.
No objection. There you are.
States 37 is admitted. Briefly, before we leave today, just to go through what has been admitted and has not, it cannot hurt. I have on my chart state exhibits 1 through 34 as admitted, 37 through 47 admitted, 55 admitted, 67 and 68 admitted, 64 admitted with the exception of AA, 88, 89, and 90 admitted, 119 through 128, 119, 120, 122, 123, 124, 126, 127, and 128, and 136.
Was one missing between 119 and 128, Your Honor?
On my list, I have 119, 120, 122, 123, 124. I believe there was testimony from Miss Maltese about the eyeglass frame and the car, but I'm not sure if 121 was admitted.
What happened, Judge, is Ms. Kappelman said that that's what she was requesting, but then when she said, I'd like to admit Stacy exhibit, it was 122 and 123.
So I will move 121 into evidence at this time, Judge.
Is there an objection?
No objection.
And after 128, Your Honor, you showed, what else?
After 128,
136.
136, and that's it.
That matches my list. Now we have a demonstrative A and a demonstrative D, which have been used. The
Yes.
advised the court no longer accepts demonstratives. Would you like to make those items court exhibits for appellate purposes?
Yes. And the foundation for 60 is ongoing at this point, also as to 64 AA. All right. 8:30 on Monday morning, we will go through any predicate or foundations that need to be addressed prior to the next witness. Have a good weekend, everyone.